My lord,
May I have your lordship leave to mention one matter, my lord?
Yes.
The matter has been already been fixed by the Honorable Justice Dinesh Kumar Sharma.
Yes.
In the meantime, the determination has been changed, my lord.
No, question is, do I have any determination to take
Yes,
urgent matters?
yes, matter. My lord, kindly see, have a look at the order of the Justice Sharma.
No. Question is, Justice Sharma is not sitting today.
No. That the determination has been changed. The second appeal matter is in my lord's determination.
Okay, is it a second appeal matter?
Yes, matter.
Second appeal application?
Yes, application. It is application stage, but matter has been fixed for application has been fixed for 24th next.
You have served notice upon the other side.
Everything I
Yes,
have
please give the slip.
Okay, madam.
my lord, may I have your lordship mention
Huh.
application in connection with the second appeal, substitution.
Yes.
My lord, application in connection with second appeal. My execution is proceeding very fast, my lord. That is the only urgency, lord.
Served notice upon the other
Yes,
side.
my lord, I have served.
Yes.
Deeply obliged, my lord.
My lord, may I leave to mention a rule? It is application for the condemnation of delay and serve the notice, my lord.
No, have you served the
Yes, my lord.
copy of the application?
Yes, my lord.
So anybody has appeared for the opposite parties?
Not appear, my lord, if I'm mentioning here.
Yes.
My lord, may I be permitted to
Okay, my lord.
yes,
My lord.
and mentioning for hearing matter.
Yes.
My lord, may I permit? My lord, may I permitted to mention MSCC appeal notice has been served upon the respondent.
The paper books have been filed.
No, paper book ready. Paper book already filed.
FMA application, lord.
Yes.
FMA application.
Application.
Intent.
MSCC case.
FMA.
Oh, first miscellaneous appeal regarding?
Regarding your lordship, the stay of suits.
No. Stay of suits means what? Is it a appeal against connection of the any order passed by the trial court? Then how this court will have the determination? Appeal from order of the trial court? Is it a civil appeal from interlocutory order of the trial court? Anyway,
My lord, I beg to mention one.
just a minute. Yes. Yes.
Lord, MSCC applications and appeal. Ready hearing.
My lord, application in connection with second appeal.
Application.
My lord, may I have one an indulgence, my lord. My lord, the matter has been fixed on 24th and 2:30 p.m. Yes, the matter.
Anyway, let it appear as to be mentioned.
May I permit to mention one application, lordship, hearing matter for a second appeal, lordship.
Hearing matter second appeal. Which year?
Lordship, 2025.
Just wait for some time. At least this month.
My lord, I beg to mention,
Otherwise, it will appear in the next month's list, monthly list of December.
my lord, I beg to mention one inclusion in the list, my lord. It's under the heading of hearing, my lord.
Hearing of?
2020 hearing of the claim petition. It's a railway case.
Yes.
After was second appeal hearing matter, 2018 matter,
Take-
2022 matter, and
Okay.
one
Yes.
application matter.
My lord, modern claim appeals, my lord. Paper book has been filed all formal.
Yes. Give the slip.
Lordship, may I be permitted to mention two applications for inclusion in connection with second appeal?
Application. Have you served notice upon the other side? Yes. Hearing second appeal, which year? 2000? Yes.
2024 first miscellaneous appeal, my lord. Hearing.
Regarding which case? Claim case?
No, not claim.
Then?
It arises out of Order 7, Rule 10.
Question is
rule.
this: how this court will have determination?
No, the appellate side rules doesn't say anything in specific regarding
Probably it has to be. It is Order 7, Rule 10.
10, not 11.
Whatever it is, it has to be admitted. Or it's a
No,
statutory.
it's admitted. It's admitted only after Order 41 stage is passed. After that, it goes to the single bench.
The first miscellaneous appeal, you see, other than claim cases,
Right.
it is the division bench which is having
Well,
determination.
remand cases are usually taken up by the single bench.
Is it a?
Remand, Order 43.
Anyway, let it appear as to be mentioned.
Very well, my lord.
Motor accident claim case, my lord. We have filed 2 can, my lord. Kindly make it for inclusion in the list, my lord.
Yes.
And your lordship for inclusion in the list. Hearing an application for claim case.
Hearing of application.
Yeah.
Yes.
Application of claim case.
Yes. Give the slip.
Mention on claim case.
Yes. Give the slip. Yes. Call the list.
I am appealing for the appellant, your lordship. I have prepared the paper book and paper book is ready, your lordship.
You are for the appellant.
I am for the appellant.
Paper books are ready.
Paper book ready. I am filing the paper book. Mr. Mukherjee is asking for the respondent.
Who is appearing?
Go forward.
Yes, record and order. Learned advocates for the parties are present. As the paper books have been filed and the matter is ready for hearing, let this matter appear on 3/12/2025.
You'll see another matter is fixed on 3rd, then 4th, Your Lordship.
Okay, 4/12/2025.
Your Lordship.
My lord, I am appearing on behalf of the petitioner in item number 3, my lord. My lord, the matter was,
Yes.
yes, the matter was sent
Let
to
me
the
see the
mediator.
record. মিডিয়েটরের রিপোর্টটা বার করে দিন তো একটু।
বলে দিচ্ছি, এই তো সবই আছে তো। কিছু ভালো। Be submitted by the leader of
তো বলছে মিডিয়েটরের রিপোর্ট ফ্ল্যাগ মিডিয়েটরের রিপোর্ট আছে, যাক এটাকে ব্যাক করতে হবে তাহলে আবার।
না জানো না মেডিসিন বলছে আমি তুমি না মেন কাছে
এক্স দেখি। Copy of the না, এইখানে এনক্লোজ, এই যে দেখুন এনক্লোজারটা কোথায়, এনক্লোজার ওর সাথে তো এনক্লোজার থাকবে।
পয়সা শুধু আছে
ওই you are appearing for?
I appearing on the petitioner, my wife. The mediation has been failed, my lord.
Okay. Let it go before the regular bench for hearing. Yes, record an order.
My lord, I pass an order, my lord.
Yes, learned advocate for the petitioner is present. Report of the mediator received. It appears from the report of the mediator that the mediation proceedings have failed. Stop. Let the matter be placed before the bench, having determination to hear civil revision cases.
Item 3.
When the appeal is ready for hearing, my lord, I filed the paperwork earlier. That's so the matter may be hard, my lord, anytime, any also. It is short.
Yes, when can you come ready?
Anytime, lord.
Yes,
Next week.
record an order. Learned advocate for the parties are present. As the appeal is ready for hearing and the paper books have been filed, let this matter appear for hearing on 25/11/2025.
My lord.
Item 5.
My lord, I beg to appear on behalf of the respondent, but I filed the application under 39(4), which is before your lordship.
Lord, I appear for the appellant, my lord. I have
Because, my lord, I am suffering, my lord, the order of injunction which has been obtained by the appellant by suppressing the material fact.
No,
and
what is this
expropriation.
can one for?
my lord, may I? This is a affidavit of service, my lord. This is my appeal, second appeal. It was admitted. Can one was initially for injunction, which was granted by the Honorable Division Bench by order dated 16th of April.
Yes,
Now, my lord, that was granted till disposal of the application.
yes.
Now, my lord, after passing of that order, we came to learn that they have put the decree into execution. The decree was for declaration and permanent injunction.
Yes.
Thus, Can 2 is my application praying for stay of that execution proceedings. And Can 3 is their application for vacating my order of injunction. Now, the second
No, appeal is admitted.
appeal is admitted is yet to be heard.
Appeal admitted, my lord, and injunction was granted. Injunction was prayed, my lord. I show from the
No,
record.
if the appeal is admitted, the appeal has to be heard out.
No, that is true. But my application is there. I
No,
filed
maybe
it.
your application is there. If during the pendency of the appeal entire case degree is executed, it will become
That is
infructuous.
why, my lord, I filed the application because suppressing the matter, your lordship knows 39(4). The
Yes.
provision which has been enumerated in the Civil Procedure Code 39(4). If any statement or averment has
So
been
let a
made,
date be fixed for hearing of this application.
yes, it
No,
is very important
all
because
three
my lord,
may be-
we are suffering. We are suffering.
No.
Even after filing this appeal, we were in possession.
No, it is your appeal.
This
No,
is their
my
appeal.
appeal.
They have lost in two courts, in
Sir.
Suit Court as well in Title Appeal Court.
So
And-
if the appeal is admitted
Yes,
by the
because
division bench, it is
my-
to be
There
heard.
is substantial question of law
My
formulated.
submission is, my lord, we were not there at the time of admission.
There was no
because
caveat.
We did not file any caveat.
Okay,
Yes.
very well, very well. Now the
Now,
question
the
is
suppression of
your
court is here.
application is to be heard out.
Yes.
No, all
That is-
three
that is
three
very
applications may be heard out.
Let
and-
a date be fixed for hearing
Lord,
of
one
your
more
application.
Very short date may be fixed,
One-
my lord.
Yes.
One more thing, my lord, they have filed an opposition to my application for injunction. This is Can 1.
No.
There
which,
was-
this application for vacating be heard out. Their application.
Well, I'll have to file an
Yes, you
opposition.
file it. Yes,
Very well.
record an order. Learned advocates for the parties are present. The appeal which is admitted is to be heard out upon filing of the paper books
And the LCR may be called for by
and
special
upon
messenger.
receipt of the LCR. So paper books have not yet been
No,
filed.
there is no direction to call for the records because the application was to be
This is, my lord,
This is
virtually
decided.
second time appearing, my lord, after admission.
Okay, now the question is, yes, an application for vacating the interim order of injunction is taken out by the respondents. You are for all the respondents.
No,
Was the, my
no.
lord, 1 to 7.
1 to 7.
1 to 7.
Our status was plaintiff, my lord. We own the case in the
Okay,
trial court.
1 to 7 is taken up. Let this application Can 2,
Can
Can
3.
3.
Can 3 of 2025 appear under the heading application hearing on
And a short date may be given, my lord. and we are
I'd like
suffering.
to file an opposition since there's allegation in
Lord,
there.
the application has been served long prior to, my lord, vacation.
Opposition be
Without
filed
hearings or order.
on or before 17/11/2025.
Lordship.
No, sorry, this today is 17.
Today is
On or
17.
before 24/11/2025.
Uh,
Reply, if any, by 27.
27.
27/11/2025. Let this matter appear under the heading application on 1/12/2025.
1st of December.
1st of December.
Very well.
Lord, kindly fix a time, my lord. Because we are suffering, my lord. At 2 p.m., your lordship, kindly.
1/12/2025 at 3 p.m.
Very well. Very well. One more thing, let the usual directions be there. Let the LCR, in the meantime, let the LCR come. Let me prepare paperwork because this has to be eventually heard out. Let the
LCR be called for.
at the
Let the trial court records be called for.
call for by special messenger at the cost of the
By
appellant.
special messenger
At the cost of the
at
appellant.
the cost of the appellant.
Very well, my lord.
Let us see when application hearings trial court record আসলে পরে হবে, otherwise application টা hearing হবে.
Yes, my lord.
Okay, then let this application be heard out.
Very well,
Thereafter,
very well, very well.
thereafter the
Very well.
LCR.
Very well. Very well.
Paper ইয়েটা কেটে দিন, TCR টা কেটে দিন.
May I just, since my application can 1 for injunction and their application for vacating, let can 1 and can 3, even the can 2 may be heard out together. That's all, my lord. My application for injunction,
The purpose you will be served. If this
Served if-
application for vacating is heard out,
along with the application for
whatever
injunction.
it is, the injunction order is continuing.
Yes, yes.
So
We have
very well,
already
that-
used, my lord, opposition
Yes,
against
yes.
injunctions.
Whatever it is,
That-
this vacating application is
The can 3 will be very well, very well. Very
Lord,
well.
1st
I'm
December, 3 p.m.
1st December, 3 p.m.
grateful.
Six, I am for the opposite party in this matter. I am for the opposite party, my lord. There is a 36 opposite party. Out of them, my lord, I am appearing on behalf of them, my lord, 22.
So petitioner is not here, okay?
My lord, the last of it. May I file my opposition, my lord, in this matter? They are enjoying the interim order.
So learned advocate for the petitioner is not here. Yes, record an order. Learned advocate for the opposite party is present. Let the affidavit. Actually, was there any direction to file affidavit?
No, my lord, there is no right.
So it is not compulsory to file affidavit in opposition.
I want to disclose certain, my lord, documents which is
Whatever
not
it is, you
annexed in
see,
the, my lord, civil division
My
application.
question is, you see, this is the purely question of law, 227
With
jurisdiction.
regard to, my lord, the application of order for my order 9 rule 9, my lord, that application I have annexed in my opposition and order 9 rule 13
Because you see,
application.
we have to consider this order 9 rule application and this order. Anyway, let the affidavit in opposition filed by the opposite party number
My lord, there is a
10.
no, my lord, opposite not 10. And my lord, I am also appearing, my lord, out of my lord 22, my lord, opposite party. My lord, some of the opposite party also died and they did not take any steps for substitution, my lord.
You are representing all the opposite parties. So,
I am representing, my lord,
learned advocate for the opposite party number 10 and opposite party number
1,
1,
3,
3,
4, my lord, I am just not mentioning them. Sleep, my lord, I am mentioning that, my lord. 15, 22, 19, 18,
1,
11,
3, 15, 22,
22, my lord, 19,
19,
10,
10,
8,
8,
11,
11,
14,
14,
18, 13.
18 and 13 is present. Let the affidavit in opposition filed by opposite party number 10
Yes.
be kept with the record. Let this matter appear for hearing. So, I don't know whether service is complete upon all the opposite parties. Yes, petitioner has served. Yeah, let the matter appear for hearing on 24/11/2025. Let the
24, 25,
25/11/2025. Let the petitioner's advocate be intimated by notice.
Yes, my lord, this appeal has come at my instance. My lord, appeal There are two appeals filed by the insurance
Okay, some
company.
correction is to be made.
Yes, my last portion of the order, your lordship kindly see.
Yes, record an order.
There is no direction upon the learned Registrar General.
Learned advocates for the parties are present. This matter is put up for necessary clarification
For this
and clarification and inclusion in order dated November 13, 2025. By order dated November 13, 2025, FMA 1326 of 2025 with COT 146 of 2024 were disposed. However, it is not mentioned in the said appeal that the Registrar General, High Court, Calcutta, shall release the amount deposited by the appellant's insurance company to the claimants respondents. Thus, the Registrar General, High Court Appellate Site, Calcutta is requested to release the sum which is deposited by the appellant Reliance General Insurance Company Limited within a period of 3 weeks.
My lord, I didn't know.
By Reliance General has, yes, yes. No, whatever amount is there, the Registrar General, High Court Appellate Site, Calcutta is requested to release the awarded sum deposited by the appellant Reliance General Insurance Company Limited within a period of 3 weeks from the date of communication of this order upon necessary verification and compliance of all the formalities. Other contents of the judgment dated November 13, 2025 remain unaltered.
Grateful, man.
Item number 8.
My lord, 9th October, granted bail, 1%.
So the state advocate is not here.
Last procession, my lord, need to produce the case diary. My lord, unfortunately, Ziarul Shodar alias Shantu's father, 12th November expired. State is unavailable, my lord.
Okay, not this week.
My lord, Wednesday, my lord, petition number 2. Father had expired.
Petitioner number 2's father has expired. No, they are on bail.
No, my lord, custody, my lord. On the ground, the huge fake currency.
No. Question is, in this matter, bail was.
Petitioner number 2 granted bail, your lordship.
Oh, petitioner number 2 is granted bail.
My lord, only 2 granted bail. And
so he is on bail.
No. 1, 3, 4.
Yes.
Rejected.
Yes.
Huge fake currency was.
Anyway, you see, that order can't be recalled. You see, because if it is a technical error, it can be recalled. I thought there is some mistake in the order of grant of bail, some rectification. But once it is rejected, you see, I can't recall the order. You move a fresh bail application. No. I passed a reasoned order. That cannot be done. You see, I was of the impression that order of bail is passed. There are some rectification. You see, once an order is passed of merit, this court does not have a jurisdiction.
On the ground, rejected your fake currency.
Whatever it is.
They prayed for correction.
Who?
State. They prayed for.
Okay, let it be not this week. Let them come. Because it is. You see, you are asking for a fresh bill. This could.
No, my lord. It was rejected on the ground. Huge fake currency was recovered. But false submission before you.
No. Question is, if you have some grievance that there are some new circumstances, you have a right to prefer a fresh bail application.
Yes.
That right you have.
Yes.
But that order cannot be rectified in that manner. Okay. So anyway, let them bring the case diary. I'm making it not this week. Let them come. Let them bring the case diary.
Not this week.
Yes.
9. 9 minutes. I am for the appeal. Well, there are 3 appeals out of the same accident. With the same accident. Take a direction. There's going to fix a date for hearing and direction be given upon the appellant to prepare the informal paper
You are for the,
for the appellant.
you are for the appellant. So 2019 appeal.
This is 19 appeals. 3 appeals, connected appeals.
So one appeal is only appearing.
But there are other 2 appeals. That is one. Which one is appearing? Not
This is
1334 is appearing before your lordship.
1334.
And there is another 1335 of 2019 and 1333 of 2019.
In all the matters you are representing,
Arising out of same accident.
there are 3 claimants.
Connected appeals. 3 claimants, minor. All are minors.
Yes, record an order.
Number গুলো লিখে দিয়ে দিতে হবে। FMA printed number.
Learned advocates for the appellant, learned advocates for the parties are present. As the paper books have been filed, let this.
I have to. There will be a direction upon.
Oh, paper books are.
No.
Let the paper books of this case be filed on or before 4/12/2025. Let this matter appear on 8/12/2025.
Along with my lord FMAT 1335 of 20.
Along with, you give the numbers,
Sir,
okay?
I am handing over. Just giving.
Along with, ওই যেটা দিয়ে দেবে ওটা।
I am grateful. কোনটা appear করছে? 1334 appear করছে তো?
Still, I am for the claimant respondent, Mr. Pahari appearing for the appellants. Of disposal. So the appeal only on the issue of filed din. Filed din. Paper din.
Your lordship, fix the matter for hearing.
Okay. Yes, record an order.
One tell us kindly. কোথায় মামলাটা আবার কবে আসবে?
হিয়ারিং এ ফিক্স এখানে হিয়ারিং হবে না।
কোথায় হবে?
হিয়ারিং
Learned advocates for the parties are present. Paper books have been filed.
Yes.
As the paper books have been filed,
And served without.
paper books have been filed and served. Let this matter appear for hearing. Yes, how soon can you come ready?
Raju, kindly fix on card tomorrow.
Tomorrow?
Yes.
No.
Next issue of quantum. No, not next week. The claimants are suffering. They lordship vacate the interim order because of they are enjoying interim order. They are asking for time.
Has been deposited.
24/12.
No, not 20. This month also. Can you see that?
This month, sorry, 24/11.
Yeah,
24/11/2025.
The entire amount they have deposited, it is not that claim get us to the money. So they are asking time. They have appeal filed in 2024. It's 24/11.
Yes. 11/12. I am appealing for the respondent claimants number 1 to 3, lordship.
I am appearing on behalf of the appellant insurance company in
In both the cases.
both the it's a paperwork name. In both the cases, I am appearing on behalf of the appellant insurance company. My learned friend, I have spoken to him. He will prepare the paper books. I'll hand him over the copies, whatever certified copies I have. My lord will fix it up for us.
Record an order. Learned advocate for the parties are present. Learned advocate for the respondents pray for time to file the paper books. Such time is granted. Let the paper books be filed on or before
Sometime December.
2/12/2025.
2/12, no.
No, my lord.
Probably he'll not be there anytime next year. January after vacation.
First week of January, lordship.
Appear for hearing on or before honor before 5/1/2026. Let this matter appear on 5/1/2026 for hearing.
Grateful, my lord. 13, I am appearing on behalf of the appellant insurance company, my lord. In this matter,
I am for the respondent.
I have taken the ground, my lord, that
So
the
paper books are ready.
paper books are ready, my lord. In this matter, I have taken the ground that the vehicle, that the passengers in a private vehicle, my lord, they are not covered. This issue, my lord, is has been referred to the larger bench of Honorable Supreme Court. My lord will kindly see. It has been referred to a larger bench, my lord, on this issue. So it's this judgment, this order is of July 2025, my lord. A number of matters have been fixed along with this matter also.
Is the matter pending before this?
Yes, not this specific matter, but the question of law is pending before
any higher bench of this court.
Not of this court, Honorable Supreme Court, on this point of law, my lord. Whatever are my grounds of appeal, on that point, it has been referred to a larger bench. That point of law.
It's a private vehicle, not a commercial
No,
vehicle.
no. So passengers in a private vehicle, whether they are covered or not, in a liability only or act only policy, this issue is pending before the Honorable Supreme Court.
Now you see, there is a decision of the Supreme Court that when Supreme Court is in cessation of the matter, the High Court should not proceed.
My lord will fix it up any day, any time
January.
next year. If in the meantime it is decided, I'll come back with the judgment.
Yes. Record an order. Learned advocates for the parties are present. As relevant question of law is pending before the Honorable Apex Court, the matter stands adjourned till 2/1/2026.
My lord.
1/2026.
My lord. Grateful, my lord.
Grateful. Now, 14, my lord, I am appearing on behalf of the appellants, my lord.
I am appearing
Last occasion, my lord, he submitted a report and I have submitted
exception,
exception.
and we are filing the reply.
Except reply of the exception.
Yes. Because
Let it be-
certain my lord contention has to be denied, which is not correct.
Copy was not served. Copy.
No, paper books have been filed.
No, I'm not filing anything, my lord.
He
My
doesn't
lord,
want.
No, application, any application is to be heard out today.
no, my
My
lord.
lord, today they have filed the report. We have filed the reply to the report.
Reply. I am received the reply, my lord. My lord. Is
No,
also
the
heard the
appeal,
matter?
the
or
appeal
the
has to be
past-
heard out by filing the paper books.
My lord, only one thing, my lord. If the records are available, I don't know whether lower court records have come before your lordship or not. My lord, if the lower court records.
Whatever the available with me, my lord, lordship can heard, my lord, even without passing a direction of paper book.
So if lower court
So
record,
Section 5 application is pending disposal.
no, that was
That is
allowed.
disposed.
That was allowed.
Allowed, my lord.
Only the appeal is to be
If
heard out
lordship
for
wants
filing of the
if
paper.
lordship wants to heard the matter without any direction of paper book, that can be happen.
But lower court records has to be
That
come.
can be, my lord. Purely, my lord, on law points, my lord. Two.
Yes, record an order. Learned advocates for the parties are present. Let the opposition file to the exception be kept with the record. Have you filed your reply to that opposition?
Opposition has not filed. He has filed a report.
Reply.
No.
I have filed a report.
Report.
My lord, as per direction of the earlier court, my lord, he has filed an exception.
Okay. The exception and the reply filed to the report be kept with the record.
Yes.
Let the trial court's record be called for at the special messenger cost of the appellant.
On the cost of the appellant.
Let this matter appear on. I'm keeping it in the month of January.
Yes, my lord.
On 2/1/2026.
Only a very one prayer, my lord, respectful prayer, my lord. Let the matter, my lord, maybe part-heard, my lord.
No, why
Otherwise-
part-heard? It's a to be mentioned stage. Why part-heard?
You want
I have not heard out the matter.
My lord, he has no objection, my lord.
I
We
am
want
ready
the matter
to.
may be heard by your
I am
lordship.
ready to start
Wait,
hearing,
wait,
my
wait.
lord.
Let it be heard, thereafter I'll make it
My lord,
part-heard.
today's in Honorable High Court, my lord, listing of matter is very, my lord,
No,
tough than
content, my
hearing.
lord. I
See,
fix
there
it.
are other part-heard matters also. I am keeping it
Your
on
lordship
Friday.
makes it part-heard because consent is there. Both parties, my lord.
Okay, you see, if I accept your prayer, then in many prayers will come like that way.
I am prayed for fix the matter, my lord. On that.
Anyway, let me hear out the matter. Thereafter I shall make it part-heard.
My lord, I have concluded the hearing.
Anyway, come on to 2nd of January.
আরে আমি একদিনে যা বলার বলে দেবো নাম দিয়ে দিয়েছি
15 and 16.
My lord, praying for not today.
Okay, not today.
কবে রাখলো
Number 18.
এই আইটেম নাম্বার 17 টা নট দিস উইক আছে, ওটাকে কালকে দিয়ে দেবেন ওই রিমার্কটা ইয়া করে।
Madam, I am for the appellant. And I am filing the paper book. And in connection with the said appeal, my lord, I have
Who is
filed one.
appearing for the respondents?
Oh, my lord, which one is that?
Yes.
But so far this, in connection with the same, my lord, I have filed one cross objection being COT number 256 of 2026.
162.
নাম্বারটা বল ভাই, আমি তো বলতে পারবো।
162 of 2000.
And I have filed one COT 162 of 2025.
No, item number 17, you are the appellant.
I am 18, not 17.
Oh, 18. 18, you are the appellant.
No, my
You
lord, I'm
are-
for the respondent.
Oh, 18, you are for the respondent.
Respondent. It's an appeal by the,
So paper books are ready.
yeah, paper books I have filed.
Now that court application has to come, that is by you.
By me.
So let it appear for hearing.
My lord.
Yes, learned advocates for the parties are present. As the paper books have been filed and the appeal is ready for hearing, let this matter appear for hearing on 27/11,
Okay.
27/11/2025,
Along with
COT
162 of 2025.
162 of 2025.
Grateful. Much obliged.
Number 19.
my lord
The paper book, your lordship has recorded that paper book has filed to the.
Yes, sir. The paper books file be kept with the record.
19 my application not for early hearing of the appeal. The file long back. That's
Anyway,
But-
this,
but
the question is the paper books are ready.
paper ready filing let the matter be.
Yes,
Yes,
record
madam.
and order. Learned advocates for the parties are present. As the appeal is ready for hearing and the paper books have been filed, let this matter appear for hearing on 26/11/2025.
Much obliged, sir.
20.
20, I am appearing on behalf of the appellant insurance company.
Respondent claimants, your lordship. Paper books have already been filed, your lordship.
My lord will fix it up for hearing any day. I'll just get prepared in the matter.
Yes, record and order. Learned advocates for the parties are present. As the paper books have been filed and the appeal is ready for hearing, let this matter appear for hearing on, how soon can you come ready?
End of November, December, beginning of December maybe.
Beginning of
This
December, your
matter appear for hearing on,
Beginning of December sometime.
okay, 4/12/2025.
My lord.
You see, and another matter already fixed on 4th, 5th.
If
Or
Fifth is a-
second, your lordship,
Fifth
second,
is a
second.
Anyway, so 2/12/2025.
Diploma.
Grateful, my lord.
Number 21. Number 21.
21, I appear for the appellant, my lord.
You are for the appellant.
I am for the appellant, my lord. The copy has been served, my lord. Affidavit service is not ready. My lord, let me, since the Union of India is not appearing, my lord, let me have another attempt and.
Yes, record an order. Learned advocate for the appellant is present. None appears for the, no, service is not complete.
Service has been complete. Affidavit service is not ready, my lord.
Okay.
If service is complete, let
as
me
the-
have
as
another attempt.
None represents the respondent Union of India. The matter stands adjourned till 25/11.
Kindly turn to after 26, my lord. After 26, let it be on 27th, my lord.
28/11/2025.
Under the same heading.
Yes, yes, same heading.
Number 22.
Lordship, kindly make it pass over, Lordship. Mr. Rajdeep Bhattacharya appearing with the appellant for the respondent. Kindly pass over, make it pass.
So 22, pass it over.
Number 23.
Lord, item 23 is insurance appeal. Lord, pursuant to this honorable court's earlier order, Lord, I have deposited the entire compensation before my lord's court.
Can number 3, my lord.
Can 3 is the appellant's application.
No, Lord, this is respondent's application, can 3.
Can 3.
The respondent claimant's application, can 3.
2 died, my lord.
Just a minute. So your application for stay is already disposed.
My lord.
Okay, so let this application be taken up.
So can I make it then?
Yes, what do you say?
My lord, I don't have. My lord is convinced. My lord, I don't have any.
Number 2. Why mother of the deceased died?
Respondent number 2, mother of the victim.
Yes. Chapana Rama Kumari died.
No, the incident took place in Asansol area.
Yes, sir.
And the parties used to decide that at that point of time in Asansol.
Yes, yes, yes.
At that point of time.
He was an employee on that day.
Now they are residing in Andhra Pradesh.
I read the paper book. So leave behind the son and husband.
Anyway, actually the appellants usually file the substitution application. But anyway.
Yes.
So now who has taken out this application?
My lord, it has been taken on behalf of the claimant respondent. My lord.
Claimant respondents. No, which respondent?
My lord, respondent number 2 was the mother of the deceased. She died.
Yes. Now who has filed this
My
application?
lord, this application has been filed, my lord. With the other two remaining respondents, my lord, who were the widow and the son of the deceased, along with, my lord, in place of mother, my lord, mother had another son. My lord, deceased's brother. So, my lord, these three are the, my lord, present petitioner before your lordship. Widow.
Yes, record an order.
Sorry.
Anyway, you see, it is not open to you to say that you did not have knowledge. The appellant can say the appellant did not have knowledge about the death. But you are one of the heirs of this party, you are saying that you don't have knowledge. Yes, record an order. Learned advocates for the parties are present. This application is taken out for recording the death of respondent number 2. It is the contention of the applicants that the respondent number 2 died on 8/1/2022, leaving behind the respondent number 1, 3 and
Husband of the deceased will be added.
no, respondent number 1.
One is the wife of the deceased. Respondent of 3, son of the victim.
No. Respondent number 2, who was the mother of the victim, died.
Yes, my lord.
Now her legal heirs are who are her legal heirs?
Para 4. Para 4 already mentioned.
Para 4. Jampana Nagaraju.
With the brother of the deceased of it.
Okay, only this A has to be substituted.
Only husband of the
Brother of the
And B, that is already on record.
already record.
Yes, recording the death of respondent number 2, Jampana Ramana. It is the contention of the applicants that respondent number 2 died on 8/1/2022, leaving behind the respondent number 3 and her husband Jampana Nagaraju as legal representatives. Stop. The grounds for delay in filing the substitution is sufficient. The abatement is set aside. Let the names of respondent number 2 be deleted from the cause title and the name of Jampana Nagaraju, husband of deceased respondent number Jampana Ramana Kumari, be substituted in her place and stead. The department to carry out the amendment within a period of 2 weeks. Let this matter appear on 3/12/2025.
Already submitted the paperwork.
My lord, a little after that, in the second week of December. My lord. In the first week, my lord has fixed up already 50.
Okay, 8/12/2025 under the heading to be mentioned.
Yes. Yes.
Yes, can disposed.
এটা আছে জানি এটা আছে এটা শুন
নামগুলো 24.
My lord, 24 is a claimant's appeal. My learned friend is not on behalf of the claimant appellant.
24.
But I'm
right.
24, it is your appeal.
Yes, my lord.
Okay. Paper books are ready.
Yes, my lord. Respondent number 3 died. Mother of the so now has been checked out.
Yes. देखी ये
Can one.
এতে আপনি আমার একটা নতুন পেপার বুক দেবেন, এতে আপনি আমাকে মেমো দেননি।
মেমো নাই
না, দেখুন।
Okay, this mother of the victim is made a pro forma opposite party.
Yes, ma'am.
মানে before the trial court also.
No. Because the trial court claim is there.
No, this Manwara Khatun died.
That. So appeal cannot find without the sign of the digit. So after judgment pass.
No, during
Mother
the
of the
pendency of this appeal, this Manwara Khatun died.
That. Only that. Her name will be sponged out.
এক সেকেন্ড দাঁড়ান।
Yes, record an order. Learned advocates for the parties are present. This application is filed. This application for substitution is filed on account of death of respondent
এখানে
number
দেখুন না,
4,
জাজমেন্ট 108 থেকে 114,
respondent.
মেমো 115, 122 থেকে 131।
Yes, respondent number 3, Manwara Khatun.
114,
As the respondent number 3, Manwara Khatun,
111,
died,
108।
leaving behind the appellant number 1, 2, and 3 are as legal heirs
Yes, ma'am.
who are already on record. Let the name of Manwara Khatun, the respondent number 3 in this appeal, be deleted from the cause title. The department to carry out the necessary amendment within 2 weeks. Let this matter appear. Matter appear after 2 weeks. Now 2 weeks. Let this matter appear on 1/12/2025.
112, grateful.
Can is disposed.
Yeah, sure.
25.
My lord, let the stay be made absolute. I have deposited the entire awarded amount. জজমেন্টটা নিয়ে চলে গেল না? Yes, করতে দিলাম, নিয়ে চলে গেল।
Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the awarded sum in terms of order dated 1/8/2025 and 19/8/2025, the judgment and award dated 10th day of April 2025 passed by Learned Additional District and Sessions Judge, Fast Track Court, Shuri, Birbhum, is stayed, Birbhum in MSC case number 4 of 2019 is stayed till the disposal of this appeal. Let this matter, okay, you have to file the paper books.
My lord, he will file.
Yes, my lord.
Let the trial court's record be called for and the paper books be filed on or before 4/12/2025. Let this matter appear on 4/12/2025. একটা ডিসপোজ হয়ে গেল ক্যান ওয়ানটা Your application was CAN 1 probably.
Can 1 was stay and can 2 was section 5.
CAN 2. CAN 2 is earlier disposed.
একটা স্টেজ
1, 1, 1.
কোনটা স্টেজ
Millard, 26 is insurance appeal, Millard. This is appearing for the first time before your lordship. Millard, I was praying for interim stay. Millard, I have made the statutory deposit of rupees 25,000 before your lordship. Millard, your lordship will kindly grant me, Millard, my lord is granting 5 weeks time, Millard, to deposit the balance amount before your lordship. And Millard, your lordship will kindly, Millard, if I deposit, Millard, your lordship will kindly, Millard, make the stay continue till further orders, Millard, because Millard, if I deposit at the same time, Millard, my deposit they will continue with the execution, Millard, after 5 weeks.
I'm granting you
5
time to
weeks
make the
stay.
further deposit. Okay. In the meantime, the matter is pending before the trial court. You intimate the trial court that
Millard,
the
may I just indicate the difficulty? May I just
Yes.
indicate the difficulty? Millard, your lordship is kind enough to grant me 5 weeks time
Yes,
to
yes.
deposit the balance amount. And in the meantime, Millard, your lordship is giving me interim
Yes,
protection. That
yes.
till 5 weeks, nothing to be done.
Yes, yes.
Millard, what have the difficulty what I face, Millard, the client insurance company. Millard, after 5 weeks, let us say, Millard, on the 6th week, since my lord's stay is limited to 5 weeks, Millard.
Oh, that can be extended. You mentioned the matter.
Millard,
That
Millard,
can be
Millard,
extended
Millard,
at any time.
to avoid the complexity, Millard,
Yes.
your lordship, Millard, I have got a series of Millard honorable division bench orders, Millard,
Yes.
as well as Millard, the last bench, Millard, presided by Honorable Justice Bandya, Millard, to protect us, Millard, as only to make it a little more, Millard, easier for us, that if I deposit, the stay will continue till further order of your lordship, or till disposal of the stay application. Only to that extent, not till appeal, Millard. Millard, if I deposit, Millard, that deposit would be secured, Millard, in a nationalized bank, in a renewable fixed deposit. And Millard, the stay would continue till disposal of a stay application. Only to that extent, Millard.
Yes, record an order.
I'm extremely grateful to your lordship, Millard.
Learned advocates for the appellant is present. As the learned advocate as the appellant has deposited the statutory amount,
My lord.
there shall be an interim order of stay of the award dated
11th day of
11/8/2025
My lord.
passed by learned additional district judge, fast track court, Alipur, 5th fast track court, Alipur, South 24 Parganas, in MSCC number 3 of 2014 shall remain stayed for a period of 5 weeks.
Obliged, your
Stop.
lordship.
The appellant is granted liberty to deposit the awarded sum
Lordship.
along with the interest within this period of 5 weeks.
My
Stop. In the event the appellant makes deposit of the awarded sum along with the interest, excluding the statutory amount within the period of 5 weeks, that the stay order shall continue till the disposal of CAN 1 of 2025.
Or till disposal of a stay application. To make
The
it easy.
disposal of this application, CAN 1 of 2025.
Lordship, extremely obliged to my lord, Millard. And Millard, would my lord be kind enough to direct my lord's officers that once the money is received, Millard, to invest it in a Millard renewable fixed deposit so that the money can Millard, without my lord's order, Millard.
The Registrar General, upon receipt of the deposit, shall in the usual in the usual course deposit the same in the nationalized in any of in a nationalized bank. That is the usual order.
No, Millard, what happens, Millard, Registrar General, Millard, the money what we deposit, Millard, they have got various accounts. Millard, if my lord order is there that to deposit it in a renewable fixed deposit, Millard, it will earn more interest.
Otherwise, a deposit in a nationalized bank.
With Millard renewable fixed deposit,
A fixed deposit of a
nationalized bank. Extremely obliged to your lordship. I'm grateful to my lord. Millard, that because the rate of interest would be a little more, Millard.
Yes.
That is
Made it nationalized.
Yes,
bank.
yes. This would do.
27.
Millard, 27, Millard, is the similar application, Millard. on behalf of my client, my lord, this is also, my lord, a stay application before your lordship. I have made the statutory deposit. I was praying for the similar order, my lord. Obliged to your lordship, my lord. My lord, the last matter, my lord, made it returnable on the date. Perhaps was not given. Liberty to mention, my lord, perhaps it was there.
Anyway, after the deposit, okay,
Lordship.
you mention the matter.
I'll mention the matter. I'll mention the matter. Obliged to your lordship.
Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount, there shall be an interim order of stay of the judgment and award dated 21st day of August 2025, passed by learned additional district judge, first track, first court, Tomluk, in MSCC number 546 of 2021
Lordship.
for a period of 5 weeks.
My lord.
Stop. The appellant shall take steps to deposit the awarded sum along with interest within the period of 5 weeks, excluding the statutory deposit.
Grateful to your
Stop.
lordship.
In the event such deposit is made within the period of 5 weeks, the ad interim order shall continue till disposal of Can 1 of
My lord, my lord, my lord.
2025.
Lordship.
The Registrar General shall in the usual course deposit the amount in any fixed deposit of a nationalized bank.
Extremely grateful to my lord. I'm obliged.
Yes, dispose. No, not
No,
dispose.
no. No, this was only.
28.
My lord, 28 also, my lord, I was praying for the similar prayer before your lordship. My lord, this is also after deposit of a statutory amount, my lord, I've come up before your lordship.
Yes. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount, there shall be a stay of the judgment and award dated 1/8/2025, passed by learned judge, bench 10, City Civil Court, Calcutta, in MSC case number 219 of 2017 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the sum awarded along with interest within the period of 5 weeks. Stop. In the event,
My lord, I must indicate, my lord, in this case, my lord, there were two insurance companies. The award was equally bifurcated, not a proportion between both the insurance.
yes, whatever is the awarded sum,
My lord, my share, because my lord,
awarded
my-
sum,
of-
the awarded sum
of
upon
appellants-
the appellant,
upon
the appellant,
extremely obliged, your lordship.
upon the appellant,
My lord,
along with interest.
grateful to your lordship.
Okay. In the event deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Till disposal of this application. This order of stay is limited
My
to
lord.
the appellant.
Extremely grateful to your lordship. Yes, my lord,
So
they
I'm
should not.
limiting to you.
Yes. They should not be deprived of, my lord, of the other company. Lordship. Obliged to my lord. I'm not Registrar General directed to.
The Registrar General in the usual course shall invest the deposit in a fixed deposit of a nationalized bank.
My lord. Yes.
29, my lord. For the appellant petitioner, my lord, in this matter, my lord, Section 5 application and other applications are there, substitution application. The other side is not appearing.
Section 5 is pending to be disposed.
Yes, my lord.
Section 5 copy of the application is served.
Yes, my lord. Opposition reply, everything was given, but the other side is not.
Okay, how long? How many days delay in Section 5?
1308 days.
1308 days.
Yes, my lord. Everything was there. My lord, I am giving the notice again. I am giving
Okay,
the.
so let it appear day after tomorrow.
Yes, my lord. Day after
Sub-
tomorrow.
Yes, learn it.
Mr. Sutroth is appearing.
Huh? But you intimate him.
Yes, my lord. I am intimating.
Okay, not today and tomorrow, on Wednesday.
Yes, Wednesday.
In this matter, I am appearing on behalf of the petitioners.
Sir, I am for the caveat respondent, my lord. My lord, praying for not today only, my lord.
Okay. Okay, not today.
It is section 5 application, my lord.
There was a section 5 234 delays, my lord. I am praying for not today only.
Okay, let him come ready tomorrow.
Yes,
My
my lord.
senior is appearing on.
Yes.
Yes,
I'm
tomorrow.
I'm keeping it tomorrow.
Yes.
31. 31, I am for the appellant, my lord. There are two applications.
Number 1, 2, and 4.
Numbers 3, 3, and 3.
There are two
You are for the
applications.
appellant.
I am for the appellant, my lord. The section 5 application and application for leave to prefer appeal. I am a non-party in the suit, my lord. I was a purchaser of the flat in question, my lord, in 2006. I was not made a party. Now, during execution, my lord, the bailiff came and I came to learn that a decree has been passed. I'll just give the background, my lord. Suit was, my lord, by my learned friend's client. It was a brokerage agreement. He was a broker who, my lord, had an agreement with the, my lord, owners that he will clear the property. Property shall be developed and 2 flats shall be conveyed to him as
So let
brokerage.
this application be taken up, your application for leave.
Leave, I was wondering, section 5 your lordship will take. Leave possibly with the, my lord, appeal, my lord.
No. Question is, no, your section 5 has to be allowed first. Then only the question of leave.
My lord. My
Leave
lord.
and admission, that is to be decided.
My lord. Kindly my lord, take up my section 5, my lord.
And 1.
My lord, the judgment, date of the judgment is 16 November 2021.
And 2 is the section.
Can 2.
And 2.
No, this can 1 lekha tha hame.
What the can 2 letters?
Can 2. Can 2.
Can 2 na?
So all the respondents are represented. A can to din. Can to oh এটা can 1 later. How many days delay?
1040 days, my lord. But my explanation is, my lord, that I was a necessary party. I was not made a party in the suit. And I came to learn, my lord, about the suit and the appeal, which is now admitted by the Honorable High Court during, my lord, execution proceeding.
Yes, which paragraph you have stated?
Paragraph, my lord. 9 onward, my lord. 9 onwards is my knowledge. And before that, my right is paragraph 3. Then during pendency, I have purchased. Paragraph 3, then 9. You वापस करছো? Yes.
So have you taken out any opposition to this application? Yes.
Time it is appearing, self-same degree has been challenged by the principal defendant, and that appeal has been
admitted.
So
The
it
same
will,
question.
obviously, this appeal will be admitted by the honorable.
Now, how many days delay?
1040.
Kindly record my objection.
Yes, record an order.
Kindly record my objection.
Learned advocates for the parties are present. Are learned advocates. This is an application filed by the appellant, who was not a party in the party before the trial court, where trial court, and subsequently came to know when title execution case 5 of 2022 was filed. Before which court?
Additional court. Civil judge senior.
Senior
Civil judge
Just
senior division additional court Hooghly.
Okay, before civil judge senior division additional court
Hooghly.
Hooghly Shodor. The appellant
No, no. Additional
petitioner has shown sufficient grounds
execution.
of not sufficient grounds for condonation of the delay. Upon hearing the learned advocates, this court is of the view that as the appellant petitioner was not a party in the before the trial court and has given sufficient grounds for condonation of delay, the delay in preferring this appeal should be condoned. Thus, I condone the delay in preferring this appeal. The application CAN 2 of 2025 stands disposed.
Deeply obliged, ma'am. Affidavit of service file may be kept.
The affidavit of service file be kept with the record.
Deeply obliged, ma'am.
Yeah, LBC the deal করতে পারবে।
তার অ্যাডমিশনটা তো একসঙ্গে হবে।
ছড়িয়ে রাখা যাবে।
32.
32, madam, appealing for the appellant, the plaintiff appellant in this matter. If your lordship, madam, kindly take the last order, madam, if your lordship. Last order to go.
This application is to be disposed. You are for?
Well, I am for the plaintiff appellant, madam. This is suit for eviction, madam.
Who is for the respondent?
Madam, there was a direction, madam, for service, madam. I have served, madam. This is the affidavit of service, madam.
No. Which application is to be taken up?
Injunction.
Madam, injunction. Roshida Khatun.
The appeal is admitted.
Yes, yes. It has been admitted, madam. Lordship will kindly see the order dated 17 June 2025.
Let's-
Madam, Lordship will kindly takes the order, madam. If your lordship. File taken order. Order. 19.
So till the disposal of this application, this interim order is continuing.
Well, I only want let this injunction may be continued till the disposal of the appeal matter in the
No,
meantime.
no, actually that should be passed upon hearing the other
Yes,
side.
but service has been effective. They are named.
Let me
But
see.
they have also in the trial court.
So you do one thing, you serve the trial court advocate.
Trial court advocate, this there is nothing. Execution case is also not pending. It was my suit, my lord. My lord, suit was dismissed. We prefer an appeal, my lord. Now the point is only, my lord, whether they are tenant or not, my lord. The admission on the ground that in section 17 the application they have admitted us.
No, your injunction was they should not part with the position.
Injunction is, my lord, if your lordship kindly sees that, an order of injunction we passed from not to transfer, you cannot transfer, but alienate income and part with the possession and nothing else. And now, my lord, to
Okay,
be
give me the affidavit of service.
Yes, yes, I have already handed over. Affidavit of service. এটা বের করতে এটা কোথায় জাজমেন্টটা কোথায়
There is only one respondent or how many?
My lord, respondent is, my lord, one, yes, and others are all performed. Well, only one respondent, man. Well, I have also served in Bihar also, man, I have served. But this is a judgment of affirmation, madam. Well, it can, the appeal is also on the point of that whether I am a landlord or not. And they have admitted me as a landlord, but the trial court, my lord, went into a third case, my lord, and dismissed my suit.
You better do one thing. Serve a notice, give a fixed date. I'm giving a particular date because you are now protected by this order of injunction. Yes, record an order. Learned advocates for the appellant petitioner is present. None appears for the respondent in spite of service of notice. However, in the interest of justice, the appellant is directed to communicate the next date of hearing to the respondent along with the copy of the injunction. Let this matter appear on 27/11/2025. So intimate the date.
Well, I have to serve to the respondent only because when in appeal court, they did not contest. There is no lawyer, even the lawyer will also not accept the service. So
Okay,
it's
that
better-
the notice of appeal has to be sent to everybody.
Yes,
But so far
only
this
to
injunction is concerned.
Injunction, well, I'll serve to the respondent only.
Yes, serve the date, the notice, mention the date and serve a copy once again. I'm keeping it on 27.
Yes.
Service.
33. Well, 33, this is also, I am for the, well, I am for the plaintiff appellant before your lordship, my lord. Well, this is a suit for eviction, my lord, on the ground of reasonable requirement, and my lord 2G. My lord, the suit was decreed after that appeal court, my lord, came to the finding 2G doesn't apply, my lord. But the issue has not been framed in respect to the reasonable
Yes,
requirement.
Mr. Bhattacharya, you are representing?
I'm representing respondents. Respondent, my lord. So, my lord,
So what is this CAN 1?
my lord, CAN 1 is, my lord, lordship will kindly take, my lord, CAN 1 is injunction. And this is my affidavit of service, my lord. Affidavit of service may be kept on record.
No, your learned friend is representing all the respondents.
Yes, 3 respondents, okay? Start from. One,
I'm,
two,
I'm
three.
representing 1 and 2, respondent number 1 and 2.
1 and 2.
Hima?
No.
Well, this is a case, where we have prayed for an injunction, and also the nuisance are seriously created. Lordship will kindly seize the complaint, and after that also there are complaints and there are videos also. So the lordship kindly takes last order. Now, there was an order of injunction at the time of admission.
Let me see.
Maybe. Yes. Well, order lordship will kindly 18th June 2025.
Yes, from selling, transferring, alienating, encumbering the suit property.
Yes.
That is there.
Yes. So, my lord, today, my lord, what I am praying before your lordship is that, my lord, a serious nuisance has been created, my lord. Now, I can come with the videos if your lordship fixes a date, I can come with the videos, my lord. Serious slang languages has been used. The petitioner's wife resides over there, my lord. The petitioner is a government servant, my lord. Seriously, my lord, disputes are creating, my lord, after this order of injunction has been passed, since long. So,
What type of allegations? Have you filed a supplementary affidavit to that?
If your lordship directs me, I will file to that so that to bring the records in respect to the complaints. And Mr. Bhattacharya is appearing. I will be only humbly praying before your lordship, but this nuisance may be stopped.
So file a supplementary
I
affidavit.
will come back then.
Yes, record an order.
Injunction.
Learned advocates for the parties
My lord,
are-
DD I have annexed, my lord. Lordship will kindly see, my lord. The complaint, my lord, I have made on the 7th March 2025.
No, this is a pursuant to the order passed by the admission order passed by the division bench.
Yes,
This is a subsequent incident.
Yes, yes.
So
Subsequent one. It's a continuing incident. And after that one, I have videos, man. If a lordship, man, I'll come with the
yes,
certificate.
learned advocates for the parties are present. Learned advocates for the appellant submits that certain acts are being committed by the opposite parties pursuant to the order of injunction being passed by this court. The learned advocate for the appellant is granted liberty to introduce these facts by way of supplementary affidavit. Let this matter appear on. How soon can you come ready?
Man, 2 weeks later, man, I'll come back with an certificate.
2 weeks for supplementary affidavit. Okay, 1/12/2025. Let this matter appear on 1/12/2025.
Let my learned friend give an advance copy.
Yes, an advance copy of the supplementary affidavit shall be served upon the learned advocate for the opposite party.
But then when they want to deal with the opposition, if they want to file any opposition, man, they can. Man,
The respondents are entitled to file affidavit in opposition to the application for injunction as well as to the supplementary affidavit. Let the affidavits be made ready on or before 1/12/2025. Yes, no. Pending. Let this matter appear on 1/12/2025.
My lord, I am appearing on the behalf of the respondent appellant claimant, my lord. There are two analogous cases, my lord, arising out of the same accident, my lord, being FA number 1722 and 1734. My prayer is that, my lord, both the matter will be tagged together, my lord. Please,
My lord, actually, 3 analogous matters may be tagged together and heard.
That is 34, 35, and 36.
No. 35, 36. Only 34 is come with this chapter.
Only 34.
Yes, my lord. It was tagged with the previous before the previous batch, my lord. Check করা দিন, হ্যাঁ।
Yes, record an order. Learned advocates for the parties are present. Let this appeal appear along with FMA 1722 of 2019 as well as FMA 1734 of 2019 on this week.
No, my lord.
Okay, on 25/11/2025.
Much well, my lord.
Yes, call the next.
My lord, this matter I am for the respondent insurance company. My lord, I am let this matter be fixed for hearing on Friday,
No,
my
my
lord.
lord,
Friday, my lord.
Your lordship, my lord, the matter appear, your lordship desire to place the matter, my lord, earlier occasion, the hearing. My lord, let me argument, my lord, be.
My lord, let this matter be fixed at least day after tomorrow.
Yesterday night, I had a talk at
My lord,
length with
my
him.
lord,
My lord, she
my
is
lord.
agreeable to do this matter.
My lord.
Let her come ready.
Yes,
My lord, your
I'm
lordship,
grateful, my lord.
kindly allow me, my lord.
Day after tomorrow, my lord, not today, my lord. Let her
My lord,
make
my
him
learned
submit
friend
it
will
day
take
after
the
tomorrow.
notes, my lord, your lordship, kindly take the notes. I shall finish
Yes,
my
record an
argument.
order. Learned advocates for the parties are present. Let this matter appear on 19/11/2025 at 3 p.m.
I'm grateful, deeply obliged, my lord. Judgment গুলো বার করে ফেলে রেখেছি।
I am for the respondent, my lord.
I am for the appellant. My lord, this is a injury case under
Let me
section.
see. Paper books are ready.
Yes, ma'am. এরকম করেছে পেজ বোঝা যাচ্ছে না।
সবই আছে, ভালো করে দেখো, সব আছে।
মানে judgment is page 11, your lordship.
Yes. Yes, what is your grounds of appeal?
My lord, twofold ground.
Yes.
Firstly, income. My lord, accident took place on 29th April 2014. Learned tribunal accepted monthly income of the victim rupees 5,000.
Accident took place in 2014.
14. April 2014. My lord, as per our various decisions of our Calcutta High Court, my lord, 14th accident, my lord, the income should be, where the income was not proved, should be 4,000. And secondly, my lord, Dr. Vinoti Das, without treating the victim, issued disablement certificate to the extent of 30%, which should not be accepted.
Yes.
My lord, after the accident, victim first treated in the SSKM hospital for only 6 days. "29th April 2014, he admitted and discharged on 6th May 2014.
Yes. No, regarding the victim, what was the occupation? Age 21 years.
Age 21 years.
What is the occupation?
Tailoring, my lord, tailoring.
Yes,
Tailor.
tailor.
It was not proved, my lord.
No, did his employer adduce evidence? He has own business of tailor.
Yes.
No, did he adduce that which place he has the tailoring
No,
shop?
no.
Only that he was a tailor.
Yes.
Anything was put in the cross examination. Whether which shop he has, where is the shop?
No, my lord.
On a deposition of PW1, page 32. 30 is the chief.
Page 32.
30 is the chief, my lord.
Yes.
কিরকম করেছে?
Yes.
32.
ওই তো
32 is a cross examination.
32.
Yes. How much is the amount awarded? Total amount?
6 lakh something.
5,59,500.
Yes. Where is the doctor's examination?
PW3. তারপরে
My lord, page 34.
Yes. Yes. Where is the certificate of this doctor? Which exhibit?
Page 54, 55.
Page 54.
কিছু হবে না।
So the doctor had stated that she had examined. She had examined.
Clinically examined.
That means in a chamber.
Yes.
So that is. Let
My
us
lord,
see.
accident took place 2014.
Yes, yes.
Doctor examined 2017 without X-ray.
No, what were the documents perused regarding prior to issuance of certificate? That is which page? Doctor's cross-examination? Yes, this is. Discharge certificate and the treatment papers, these were exhibited.
Yes.
How long was the petitioner in the hospital? How many days?
6 days, SSKM hospital.
6 days.
Then 23 days total.
Oh.
Thereafter, one time nursing home at Diamond Harbour.
No, in
Twice.
SSKM hospital, he was there for 6 days.
Yes.
Again 10 days, again 6 days. Total 23 days.
Six days. And the other hospital?
Other nursing home, Susto nursing home, 10 days. Again on 6 days. Twice, he admitted twice. Total 23 days he admitted the nursing home and hospital.
So the case was instituted in 2014.
Yes.
And during the pendency of the case, this person got himself examined by the doctor.
Yes.
My lord, page 34, your lordship seek cross-examination.
Disability not denied by the
No,
insurance company.
medical board is required to be formed in case of more than 50% disability.
More than 40%, my lord.
40.
More than 40, medical board has to be constituted.
Yes.
My lord, your lordship see page 34. Cross-examination.
34.
Wrote the earlier act prior to the amendment had stated, if the disability is more than 40%, then the private doctor's opinion would not be taken into consideration. Under the act, the Disablement Act, the issuance of disablement certificate has to be done by a medical board, duly constituted medical board by the state of West Bengal.
Right. If it is above 40%.
It's above 40%. Now after the last amendment, this 40% has been given a go by. There are different kind of disablement has been, made effective there too. I'll show it to in one of the cases when it is required. But earlier, prior to this particular amendment,
Above 40%.
it was for 40%. It was mandatory. That
the medical board has to be constituted.
Certificate is required if it is over and above 40%.
Yes.
My lord, in the cross-examination, in the first line, I have never treated the patient. None also referred the patient to me. Fact that I ascertained the disability of the patient for this particular case.
And it was a non-scheduled injury.
Yes.
No, in case of non-scheduled injury, is the procedure adapted is correct? Non-scheduled injury.
আপনি ওটা জজ সাহেবকে পড়ান, জাজমেন্টটা রাজকুমারটা পড়িয়ে দিন না, তাহলে অনেকটা সুবিধা হয়ে যাবে, আপনারও সুবিধা হবে।
সুবিধা হবে না, একটা অর আছে,
হ্যাঁ,
non-scheduled
অর
injury.
আছে,
Yes, yes.
হ্যাঁ সেটা
সেটাও পড়তে হবে।
হ্যাঁ
হুম।
সেটা দেখিয়ে দেবেন।
দেবেন
এই ইয়ে গোপা
এটা নিন,
নাও,
এটা তো সুবিধা, এটা সকলের সুবিধা হবে।
যা আছে দিয়ে দিন।
My lord, I am showing, my lord, one of the decision of the apex court. Rajkumar versus Ajay Kumar, 2011 one Supreme Court cases, page 343. Your Lordship, see this judgment.
Yes, which page? Okay.
পেজে আছে, ফার্স্ট পেজে
Paragraph 13 started, my lord.
প্যারাগ্রাফ 8 থেকে আছে আর সামারাইজেশন এখানে আছে। স্টার্টস ফ্রম প্যারাগ্রাফ 8 7। Paragraph 13 is the summary. Otherwise, the judgment in detail starts from paragraph 7. 13 is the summary.
Okay, this is the guideline is there. Yes, so the two grounds of challenge is this income and the
Disablement certificate.
disablement certificate.
Rather, disablement.
Yes, what do you say?
My lord, regarding income, kindly, my lord, the page 6 of written statement filed by the insurance company. Para 10.
Yes, which page of paper book?
Page 6, my lord.
Page 6.
WS, written statement filed by the insurance company.
Yes.
My lord, kindly see page 10, para 10.
Yes.
That the statement made in paragraph 1 to 7 are matters of record. The claimants are to stick to thereof to substantiate the statement. So there is no specific denial by the insurance company challenging the age and income. Both. This
No,
is
regarding proof of age, what was produced before the tribunal?
tribunal produced the not kindly see me. Voter ID card, Aadhaar card, both.
Voter ID card and Aadhaar card.
তাদের 21 আসছে স্যার number 1 number so 18 will be multiplied then another thing is kindly see the evidence of PW1 page my lord that is the claimant page 32 my lord page 32
Page 32.
Finally, and also page 30 also, this is the examination chief, para 4, page 30, my lord.
Page
At the
32.
time of accident, I was aged about 21 years. This is the affidavit chief. He used to undo 5,000 taka per month by doing a job as a tailor. But in evidence 32, my lord, there is no specific denial by the insurance company regarding the age and income. Only point para cross-examination last para. I do not have any paper to establish the fact that I was earning, but there is no denial. তোমার কোন কাগজ আছে কিনা? But nothing. There is no specific neither in the WS nor in the evidence in cross-examination. Gross failure on the part of the insurance company. Even they admitted, not a fact, I am entitled to get, no, not a fact, at present I continue my job. So Taylor also admitted. তুমি এখন কাজ করছো না. So Taylor also admitted, profession also admitted. Then regarding my lord, I am writing the decision of the Honorable Supreme Court. Minimum wages in 2012. This is the decision of the Honorable Supreme Court. I take. Where minimum wages in 12 to 200. This is the Supreme Court is there. Another also decision of the Supreme Court. Several decisions of the Supreme Court and High Court. My lord is not.
No, where is that judgment? Okay.
Minimum wages in 2012.
Yes.
Specific বলে দিয়েছে my lord. In 2013, same. This is the decision of the Honorable Supreme Court. 2013. There are also no evidence about income. So this is the 3 judges versus including Chief Justice Supreme Court. That's what I think. 3 judges bench including Chief Justice Deepak Mishra. 6,000 or the 5,000. I demand 5,000 only. A tailor can more than that.
No, his age. He may be an assistant, tailor's assistant.
Not denied by the insurance company. There is no
Having his own
suggestion.
business is one
My
thing.
lord, there is no suggestion even that you are assistant of it. No, nothing. Nothing. Insurance company did not put any question to the.
Okay, so these 3 decisions you are relying.
There is another decision of the Honorable Supreme Court. Then regarding the disability certificate, the income regarding disability certificate, my lord.
Yes.
My lord, kindly see. This is the Calcutta High Court decision. I am filing the Supreme Court decision also, where, my lord, it is not necessary the doctor who examined and subsequently came before before the court. That certificate is admitted by the Calcutta High Court division main decision. This is the Supreme Court decision, my lord. Where, my lord, kindly see first the evidence. What the evidence? My lord, kindly see the evidence of PW 3, doctor, page 34, my lord, page 34. My lord, kindly see, there is no specific denial by the insurance company regarding disability certificate. The certificate is not accepted. This is no, there is no specific denial. No challenged by the insurance company. No question was put to that witness. The exhibit is not correct. Even they do not put any question that you are not the qualified practitioner. Supreme Court, this is the decision of the Honorable Supreme Court. Percentage of disability needs to be assessed only by a qualified medical practitioner. No case of the respondent, the doctor who assessed disability is not a qualified practitioner. This is
what? Calcutta High Court.
This is Supreme Court. Here also this is the Supreme Court decision. Here also the private doctor treated the injured and assessed disability. Moreover, they did not challenge the certificate. Neither they put any question to the doctor that this is not correct. So all are admitted by the insurance company. This is also decision of the Honorable. And after 2.5 years, it was assessed by the private doctor. This is the decision of the Honorable Supreme Court. After 2.5 years, the assessment was made by the private doctor. This is the Supreme Court decision. This is also Supreme Court decision. All are Supreme Court decision, but the Supreme Court admitted. Sir, my lord, kindly go the 2005 242 Calcutta High Court specifically, that is a problem if a doctor treated the injured in a hospital like Hooghly, in a hospital. Then he transferred to Delhi, then he transferred to Bombay, then again he transferred to London. Then it is possible for the claimant to go to that doctor to assess the disability. That's why Supreme Court says my friend has taken that para, mildly see the page 23 of the memo of appeal. My lord, kindly 5, 6, 7. Page 26, my lord. Page 26. Calcutta High Court are specifically mentioning this point and clearly observed that it is not possible for a man, a layman.
Okay.
My lord,
Anything else to add?
My lord, 7, page 26, 7.
Page?
The learned tribunal ought to have directed the claimant to examine the doctor who treated the this is not. Kindly, page 10. Learned tribunal also ought to have considered and settle the principles of law to the effect doctor who treated an injured or who examined him.
That is page para 9.
Yes, para 10, my lord.
Para 10.
Yes, my lord.
No, which case? That is
This page 27.
Oh, page 27 of the?
Of this appeal. Memo, I am reading from memo of appeal.
Paper book?
Yes, paper book.
Okay.
Paper book, my lord.
Page 27.
Yes, my lord. Learned tribunal written these things. In fact, the doctor who treated the injured claim or who examined his
page 27 of the paper book.
Huh?
Page 27 of the paper book.
Yes, my lord.
That is the grounds.
Yes.
Ground number 10.
Yes, my lord. My learned friend at that point. Only injured, not or who examine is up to assess the extent of permanent disability can give evidence only in regard to the permanent disability.
No, page 27.
Yes, my lord.
Or page 26, last paragraph. No, page 27 is ground number 10.
Yes. Yes. Where it was written or who examined the patient examination. I have cited the Supreme Court decision also. After a long time.
Now, whether the compensation awarded is just compensation or not.
Yes.
That is the thing to be asserted.
Yes, my.
Just in all aspects.
Yes. They have taken for the first time on that release, not in the Ws, none others.
Yes, that's all. Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. CAV. এটা রেখে দিন।
Update. 38, sir.
This is a insurance appeal, Miller. So, देखिए उधर आप जाइए ना. Lord, in terms of earlier direction passed by this honorable court, Lord, the awarded sum, Lord, in this case, the principal award was 63,70,000, and that with interest, Lord, I have deposited, Lord, approx.
Previous matter, my lord.
Yes.
Previous matter, entire awarded amount with interest. Deposited.
Yes, yes, yes.
Lord, I have deposited, Lord, more than 92 lakhs. That is principal with interest before your lordship's court.
Awarded sum of 62 lakh.
So, my lord, 63 lakh, my lord, and with interest, my lord, I deposited, my lord, 92 lakh, 58,750 before my lord's court. My lord, this appeal insurance company has filed, my lord, mainly on the ground of quantum. My lord, there is a little difference, my lord. The award should reduce by a small percentage. My lord, I'll tell your lordship why. My lord, deceased was a businessman. My lord, there are before I start, my lord.
Yes.
My lord, there are 3 counts, my lord, on which I have come up before your lordship. My lord, one is quantum.
Yes.
Second is, my lord, the offending vehicle, my lord, which was a truck. It did not have the route permit. London Tribunal Judge, my lord, was kind enough, my lord, to grant me the right to recover from the owner of the vehicle. My lord, I was praying for exoneration. My lord, before I proceed further, my lord, this prayer of exoneration, my lord, would not be carrying much weight. I must be absolutely clear before your lordship, because of, my lord, the right to recovery has already been granted. Supreme Court, my lord, in all the defenses of insurance company, where 149 to defense, these are the statutory defense available to the insurance company, not like gratuitous passenger, driving license, route permit. My lord, the Supreme Court is still date is of the opinion that fine, you are not liable, period. But claimant should not suffer. You pay and then you recover it from the owner of the vehicle. My lord, though Learned Tribunal Judge has granted me right to recover, still, my lord, I have come up before your lordship to pray for exoneration. Knowingly, candidly, my lord, I should say that, my lord, that your lordship would not be enlarging that ground by giving me right to recover.
No, no. Once the Supreme Court has held,
Lordship,
that has to be followed.
That has to be followed. That is
The
why,
moment the tribunal comes to a conclusion,
lordship,
that there was laches on the
part of
default
the
on the
owner,
part of the owner,
lordship.
definitely that order of the Supreme Court will have to be complied.
So, my lord, it has, this liberty has been granted. Your lordship,
Yes,
my lord,
yes, yes.
your lordship will record that, and your lordship will say that okay, your lordship would not be interfering with
Yes,
that right
yes,
to
yes.
recovery. My lord, this was the second ground, and my lord, third ground, my lord, I had taken on the ground of, my lord, this fraudulent practice by the owner of the vehicle. Why with regard to the implanting of the vehicle. My lord, in this particular case, this offending vehicle, my lord, in the last 2-3 years, my lord, was involved in 7 other accidents. In every case, my lord, this vehicle was implanted. My lord, the claim cases were initiated against the owner and the driver of this vehicle. My lord, I had taken that plea before your lordship, that this is, my lord, the 8th case. Your lordship knows, my lord, how the fraud is occurring nowadays, not in motor accident claim cases. My lord is well aware of that. But, my lord, the handicap what I has, my lord, my lord, that this plea of fraudulent activity of, my lord, this fraud, my lord, was...
Anyway, there's an investigation by the police authority, charge sheet submitted, everything.
My lord,
So how can I sit in appeal over that
my lord, that's what
at this stage?
I'm grateful to your lordship. But this is exactly what I was saying before your lordship. This particular plea of fraud, my lord, was not taken up before the court below. My lord, although, my lord, in my lord's inquisitorial capacity can still, my lord, go ahead. But this case, my lord, since nothing was placed before the court below, or even the police report was not there. So, my lord, your lordship, that particular ground of mine, that is ground number 3, my lord, again, my lord, would not be having much weightage here before your lordship. So, my lord, the
Now
main,
only
I come back.
With regard to the quantum.
I come back with regard to the quantum, my lord. Grateful to your lordship. My lord, deceased was a businessman. My lord, Learned Tribunal
Yes.
my lord, the only dispute, my lord, I'll indicate as far as now, my lord, since I'm confining myself to the quantum, my lord, Learned Tribunal considered, your lordship will kindly keep a note, my lord, 4,80,000, 480 per annum as the income of the deceased. And then, my lord, on that basis, assessment was made. My lord, my
rupees 4 lakh
4,80,000. 4,80,000
per annum.
40,000, yes, 40,000 per month.
That is, my lord, on the basis of rupees 40,000 per month. My lord,
he was a businessman.
He was a businessman. My lord, I'll only show, my lord, that this 4,80,000 was excessive. It should be brought down. Your lordship will kindly write down the figure, my lord. 4,22,901. My lord, the calculation is there. The documents are there. My lord, I have shown it to my learned friend, and he's, my lord, gracious enough, my lord, to accept that. I must admit, my lord, 4,22,901 901 should be the yearly income. This quantum should reduce to that extent. The calculation should be made
4,22,000.
4,22,901 per annum. On this basis, the calculation of income shall be made. I'll indicate to your
You
lordship
have given
why.
that calculation also. Anyway, you will give that.
I'll give that, because I have already shown, he has already been kind enough, and gracious enough, to accept that he has just, whatever is correct and whatever is true, that is to be paid. The documents, I'll show it, I'll just convince your lordship, why from 4,80,000, it will come down to 4,22,900, so that there is no confusion before my lord's mind, the income, as far as the businessmen are concerned, are calculated on the basis of last income tax return before the death. This is the norm. Last income tax return before the death. I'll just straightway take your lordship. I'll invite my lord to come to page number 76. My lord is kind enough to come to page 76 of this paper book. 76 minutes.
এখান থেকে ট্যাক্স অ্যামাউন্ট বাদ যাবে এই যে দেখেছো এই যে ট্যাক্স এটাই বলেছে
Yes.
I'm grateful to you, my lord. My lord, this is the income tax return of the deceased. My lord, this is the main document on the basis of which, my lord, we have come to, we have decided, my lord, why this income should be. My lord, your lordship kindly sees at the top right, my lord, assessment year 2016-17. My lord has seen that, my lord? Oblige your lordship. My lord, in the bottom, my lord, in the middle, your lordship will kindly see the date of filing. My lord, date of filing is 20th March 2017. In the middle, my lord, a little at the bottom.
20th March.
20, my lord, 20th March. The date, my lord, the date 2003-2017 in the middle. Your lordship will kindly see.
Yes.
I'm grateful. Your lordship will kindly take note of this date, my lord. My lord, 20th March 2017. And I'll indicate your lordship. I'm sorry.
Yes.
My lord, the date of accident, my lord, was 14th July 2017. So, my lord, this return was filed nearly 3 or 3.5 or 4 months prior to the death. This was the last income tax return.
Date of accident,
My lord, 14th July 2017.
Yes.
So, admittedly, my lord, this assessment year 2016-17, dated 20th March 2017, was the last income tax return filed by the deceased during his lifetime before the date of accident, and this ought to be considered for assessment. My lord, your lordship will kindly, my lord, indicate, I'll take my lord to the figures now. My lord, the column 1 at the right, your lordship will see 429,589.
That is gross total income.
Gross total income, my lord, the column 1. My lord has seen that, my lord?
Yes.
Gross total, my lord, is 429,589. 4,29,000 odd, my lord. And then your lordship will kindly come to, my lord, the column number 4. Net tax payable. Or column number 6, my lord.
Yes.
Total tax and interest payable, my lord. 6,691.
Yes.
And then, my lord, কোনটা হলো তারপরে?
তারপরে তো এটা TDS
TDS, হ্যাঁ,
TDS
দেখা যাচ্ছে না।
6968 7B
Total taxes paid 6,968. Total taxes paid, my lord, is column 7E. E for elephant, my lord, 7E.
Yes.
Total taxes paid 6,968. And my lord, then important is refund, column 9, 280. So, my lord, what is the outcome, my lord? 4,29,589 was the gross income.
Yes.
Total tax paid 6,968. And the refund was 280. So, my lord, from 6,968, if I take out the refund of 280, then, my lord, it is 6,688. The net tax paid 6,688. So, my lord, from 429,589, if I pay out the tax of 6,688, then it comes to the figure what I have given to my lord, 4,22,000.
The statutory deduction should be paid.
The tax was paid to the government. So the net figure of
So that was not taken into consideration.
no, my lord, learned tribunal judge, my lord, after this took note of chartered accountant's report for the last 3 months of deceased life after this, and then on that basis yearly income was assessed. That was wrong. This should have been taken into consideration.
Only this one.
Only this last return prior to the death.
That is less that amount of tax paid.
Less that amount of tax paid. Gross less tax. Net is 422,901. On the basis of this 422,901, now the deduction comes in, then the multiplier comes in, then the future prospect comes in, and in by following the formula of planner city, calculation is to be made on this 422,901. There are we will make a calculation, we will give it to your lordship. I'll also indicate why this.
I'll take it up in the after recess. You come with the calculation.
My lord.
So whatever you want to submit by way of calculation. You also.
Yes.
Whatever.
Lord, it's agreed principle because on
I'll
principle.
Take it up at 2 p.m.
Lordship come back at 2.
ইয়ে করে দিন।
ওইখানে কোথায় আছে? অনন্য বন্দ্যোপাধ্যায় তোমার আছে? তাহলে এখানে কি বলে দাও। মিলট ডিয়ার লর্ডস
yes সিং করতে হবে এখানে
Millard,
yes.
Millard, we've got a number of fixed matters before code 33. Millard, all of us, Millard, there were so many corrections. Millard, so Millard, we have.
So I'm hearing it, heard it part tomorrow.
Tomorrow, Millard. Tomorrow will
top
come.
Of the list.
Top of the list will come with the calculation, Millard.
And Millard, calculation and conclude it.
Lordship.
My lord, my submission is that, my lord, kindly take this. My lord, don't record my lord.
Whatever it
Concession.
Whatever you want to say. You give in writing.
Lord, he is agreeing to it. The lordship will kindly not record the concession.
Yes, record. Learned advocates for the parties are present. Hard learned advocates. Let this matter appear tomorrow under the heading to be mentioned.
To be mentioned. Millard, I'm sorry, Millard. Next matter, item 39. Other side is here. Millard, praying for at least a fortnight's time. She is praying. Item 39.
39 lordship, 43 lordship. Item number 39 and 43. Other side. 43 I am for the respondent.
Okay, learned. Item number 39 and 43. Yeah, এই orderটা করে দেবেন on the prayer of the learned advocates. The matter stands adjourned till 27/11.
No, lordship.
Okay, 2/12.
No,
Millard, time
in the second week of December. 7, 8, 9, 10.
The matter stands adjourned till 8/12/2025.
My lord, small submission, my lord. Item 40. God is not tagged, my lord, despite the previous order.
Okay. Come at 2 p.m.
तुम करा लेना अगर हम वहां रहेंगे तो तुम करा लेना Bless your lordship, Millard.
এই এটা কাগজটার মধ্যে দিয়ে দেবেন তো
Beautiful.
The beg to appear for the petitioner.
For the respondent.
That's why I'm beg to appear for opposite party number 1.
Hence, this application under Article 227 of the Constitution stands allowed. Order dated 23rd September 2024, passed by Learned Civil Judge Junior Division, First Court Barashat, North 24 Parganas, in title suit number 431 of 2010 is set aside. The matter is remitted back to the Learned Trial Court to reconsider the application filed by opposite party defendant number 1 for setting aside order dated 17th November 2011, fixing the case for ex parte hearing against opposite party number 1 in accordance with law. The opposite party number 1 is permitted to file supplementary affidavit to the application filed by him within 1 week from the next date fixed before Learned Trial Court, and the petitioner plaintiff shall file affidavit in objection within 3 weeks from the date of filing of supplementary affidavit, and the Learned Trial Court shall thereafter decide the application very expeditiously without granting unnecessary adjournments. It is, however, made clear that in the event the Learned Trial Court is of the view that there is chance of settlement in the suit may be referred to mediation for settlement.
Not only one submission may I make, my lord,
Yes.
since the matter is pending since 2012.
Yes.
Lord, if your lordships kindly, my lord, request the learned court below, my lord, to expedite the entire matter. Kindly add one line, one sentence.
If the matter is settled well and good, thereafter.
That's right. What you have, lord, my lord, I have nothing to say on that. If it is not settled, my lord, considering the pendency of last 10, 15
shall
years.
thereafter decide the application as well as the suit.
And as a suit, without granting any unnecessary adjournments. That will do.
As well as the suit, without granting.
Get full. Get full, lordship.
Otherwise, my lord, they will not. 1 year, my lord, 1 year, your lordship.
Actually, Supreme Court, lordship allowed that Supreme Court has passed a judgment stating that the time-bound period is not given, only to direction be given to without granting any unnecessary adjournments.
It is not a regular suit. This is a matter of preemption under the modern law. If it is suit, my lord, I could have understood.
No, I have made it clear. Therefore, that application has to be decided within 4 weeks. Thereafter, you see, how can I pass this order? Suppose anybody is agreed with that order passed in that application.
Lord, that is always notwithstanding all these effect.
Anyway,
lordship can pass the order. Lordship can pass the order. If Lord, somebody has come again, my lord, before the honorable court, that is up to them. But your lordships can pass this order. That similar to last 15 years, my lord, the matter is pending with regard to my lord preemption. Preemption matter is pending for last 15 years. Lord, kindly consider this aspect. This is up to your lordships, my lord. I need not to submit any further, my lord. Preferably within period of 1 year, as your lordships.
Okay, within 1 year.
I am grateful to your lordship. I am very much grateful to your lordship.
Grateful, lordship.
Lord, certificate copy is applied for, my lord.
Yes, that will be there.
Yes, I am grateful. I am grateful to your lordship. Item number 22.
Okay, not today. Okay, 22, yes. Yes, other side is not here.
Lordship is here, lordship. I said here, lordship. Lordship, can you text up the matter next item? Then I'm sending my junior to calling them.
Yes, call the next.
40.
Mr. Singh, he was go before Justice Bandyopadhyay, court number 33. Let me pass over.
He's not there.
Okay, 41.
41 and 42. Sir, 40. Item. Item.
Okay.
Item number 40.
Court number ये नहीं राज नहीं तो.
My lord, there is a court objection, my lord. There is a court of 136 of 2025. There is previous order, my lord, to tag the code. Why the order?
Item number 40, record and order.
Why did it order 311
Item
2025,
40,
my lord?
learned advocates for the parties are present. Let this appeal.
Only.
Okay, learned advocate for the respondent is present. Let this appeal appear along with COT
136 of 2025.
136 of 2025.
My lord, there is a earlier order, my lord, of 311 2025 for tagging the code, but they don't have done it.
Anyway, I have directed once again. Along with COT 136 of 2025. Yes, 41.
41, 42 is our page. দাঁড়ান আগে হয়ে যাক 40
Immediately, actually.
No, sure. What আমাদের অসুবিধা আছে? 41 and 42.
41 is insurance company's appeal lordship and 42 is my learned brother's appeal lordship.
Yes.
I'm cross objection.
Lordship, this is a injury case, lordship. My main points of appeal is, lordship, the disability certificate, challenger disability certificate and loss of future prospect, future income, lordship.
Yes, give the record.
Lordship. Record একটু দিন সাহেবকে। পেপারবুকটা দিন। Lordship, in this case, this is an injury case, lordship. The treatment sheet is annexed here with it is exhibit 11. It is stated that there is some fracture, lordship. Page 51 is the treatment sheet, lordship. Communicated compound fracture, right tibia with page 51, lordship. It's the treatment sheet, lordship. Fracture right tibia with deep lacerated injury right cuff, and he was hospitalized for 11 days. 5th September 2011 and discharge date is 16th September 2011, lordship. This is the medical paper.
How many days hospitalization?
11 days. From 5th September to 16th September.
Yes.
There is a fracture in the leg, lordship. And lordship, the injury report, the incident is of, date of accident is 5th of September 2011, lordship. And the injury report, disability certificate, injury report, not disability certificate, lordship. Page 39, lordship. Exhibit 11, I think. Page 39.
Oh, it was sent to the board.
It was sent. Lordship,
Issued by the medical board.
Okay.
lordship, kindly see to it. Lordship, the date is 19/11/2014. After 3 years, lordship.
Date of date of examination by the board.
Yes, lordship. 19/11/2014, lordship. And lordship, it is valid up to 18/11/2019.
18/11/2019. Yes.
Here, disability is temporary, lordship. Kindly see column, paragraph number 3. Temporary and.
So it is not revalidated thereafter?
No, lordship.
When was the award passed?
Award passed in 21st to 2024, lordship. Lordship, even the 55% disability that was considered, lordship. in the award, Lordship.
Now the question is, you see, temporary disability means that means at the time of passing of the award, it
Not
was
evaluated.
it was up to 2019 and
19,
not
yes, Lordship.
rehabilitated.
Yes, Lordship. He was temporary. After 3 years, this disability certificate was, he was examined, this disability certificate was issued. So proximate cause of accident, that is cannot be said. Only one treatment sheet is exhibited.
Anyway, it is issued by the board. No,
Yes,
there
Lordship.
cannot be dispute.
But
Only
whether this is the proximate cause of that injury, because after 3 years, in between, after 2011, after that hospitalization
no, what
period,
is
no medical
the
sheet was
disability reported as per their reported?
disability certificate. Only the medical sheet is there, page 51. That is stated that admission date 5th September 2011 and discharge date 16 September 2011. After 16 September
Okay, passing award
2011.
is anyway. You see,
But
circumstantial evidence, this injury certificate, all has to be taken together.
But it is temporary.
Yes, that has to be
Temporary-
considered.
No
The
review.
certificate was not revalidated.
No, Lordship. And the certificate says 55%, that is considered in the judgment. It is considered as a permanent. Even there is examination of the doctor, Lordship.
Let us see that examination.
Page number, Lordship 20. The doctor who issued this, kindly see the cross-examination portion, page 20.
Yes.
The cross-examination, the age of injury is not mentioned in the certificate. Thereafter, Lordship, we did not notify you that we perused the documents regarding the date of injury and treatment of Somen Mondo. Though we perused the documents, I have no personal knowledge about it. Thereafter, it is a fact that injury was temporary in nature. Thereafter, Lordship, it is fact that without an assistance of escort, Somen Mondol can travel and it is notified in our certificate. Thereafter, it is mentioned in the certificate that the case does not require review after 5 years and it is valid up to 18/11/2019. So the disability certificate was valid up to 18/11/2019, Lordship. At the time of passing of judgment, what
Okay,
is the
there was no
physical...
problem. There was no mention of any review.
No, Lordship. But what is the condition of the whether he was permanently disabled or anything?
No, temporary disabled. that is
Temporarily disabled is okay, Lordship. But that affected his further living in, that is not certain. What is the present physical condition of the injured claimant? But 55%, that is considered by the learned
Disability
tribunal as if it is a permanent disability.
Anyway, it's an expert's opinion. And what was the
And-
deposition? What was the deposition of this?
My second point and the depositions of the PW1, Lordship.
Yes. Yes. No mention about review.
Lordship. Even whether it affected his future income or anything, that is also not mentioned in his deposition. Lordship, kindly comes to the deposition of the PW1, Lordship, the claimant. First is the chief, the documents were exhibited. Kindly come to the page 13, 14.
Yes.
First is the examination in chief, the documents were exhibited, Lordship, and then the page 14, Lordship. I'm reading the cross-examination portion, Lordship.
Yes.
He, he stated that he was a student of BTech, HIT, Haldia Engineering Institute. But thereafter, second, and on 5/9/2011, I was a student of HIT. I did not complete my BE course. I did not make any statement before any police officer in connection with accident. Then says, I made statement before a police officer about my accident. It is a fact that my name has not been cited as witness in the charge sheet of such as the Bhavanipur PS case number 228 of 11 dated 22/9/2011. At the relevant time, I was unmarried. Still now, I am unmarried. The PO, place of occurrence, is about 5 kilometers away from the local PS. I was unconscious when I was shifted to the hospital. As such, I could not make any statement before the doctor. Some local person shifted me to hospital. The accident took place at about 1:45 p.m. and I regained my sense at around 8 p.m. Nearly after 15 days, my father lodged the FIR with the local PS over the accident. I do not know who made statement before the attending doctor. I deny the suggestion that I made statement before attending doctor to the effect that I sustained injuries while on a motorcycle. I deny the suggestion that I have made false statement to the effect that after the accident I lost my sense. My father was an eyewitness to the occurrence. I narrated the incident to my father. I deny the suggestion that I have made false statement to the effect that I was pedestrian and I was knocked out by the offending vehicle, Tata Indica car. There were denial suggestions, denial portion. I deny the suggestion that I did not sustain any serious injury in the accident. I deny the suggestion that my claim is false and excessive. I deny the suggestion the insurance company limited is no under obligation to indemnify the compensation by the owner. I deny the suggestion that the driver of the offending vehicle had no valid
Anyway,
driving.
this is the immaterial
Yeah.
type of
Yes,
cross-examination.
Lordship,
Whether how can this person know whether he has a valid license or not?
Lordship,
This
in
type
the
of not relevant. This type of
cross-examination, it is not clear from the cross-examination why he has not completed his BE course, Lordship. And what is the effect of this, whether this accident, due to this accident, he has become incapable
No,
or
who saw the vehicle number? This person was unconscious.
he was unconscious, but
Vehicle number?
There is a statement of witness who claimed to be eyewitness, but
the other eyewitness is there.
Two is there, Lordship, but kindly comes to page number 17, Lordship. It's the 16, 15, 16, 17. 17 is the cross-examination.
Yes.
But he was not named in the charge sheet. This is the person who is claimed to be the eyewitness, Lordship. One, Prushanto Mali. The distance between my residential house and place of occurrence is about 100 to 150 meters. I was present at PO at the time of accident. The PO is situated just 30 cubits away from bus stop. At that time, I was alone in the bus stop. I stayed at the PO for 20 to 25 minutes after the accident. Many people gathered there after the accident, but at present it is not possible for me to say their name. I took the injured to hospital and the injured was admitted. He admitted, he said. 2 or 3 local people were also present at the time of admission of the injured at the hospital, but it is not possible for me to say their name. I did not put my signature on the admission register of the hospital. It is not possible for me to say who signed at the time of admission of the injured. I did not state anything before the doctor regarding the accident. I did not see any motorcycle at the place of occurrence. At present, it is not possible for me to say the exact date on which I was examined by police. Police interrogated me at the place of occurrence. It is also not possible for me to say who lost the written complaint on which date before PS regarding this accident. Not a fact that I did not see the accident in my own eyes or that I was not present at place of occurrence at the time of accident. Not a fact that I deposed falsely. This is the cross-examination. No, Lordship.
Anyway, the witness is there because an unconscious person cannot say the vehicle
No,
number.
Lordship. But he has not stated the vehicle number. He has stated nothing to the police. He has stated.
No, question is regarding, he saw the incident.
He saw the incident. He told that he brought.
Any cross-examination, what was the vehicle number?
No, nothing, Lordship. PW1 is.
No, in the chief, he has stated, so-and-so vehicle dashed him in the chief. Examination in chief?
Yes. That
This and vehicle dashed him, so he was a witness.
But in the charge sheet, he was not named. as
Yes,
the
yes. Police
witness.
did not
No.
mention him in the charge sheet.
Acha, Lordship, one thing in the impugned judgment, Lordship.
Yes.
My second point is, one is the disability, regarding the disability, and the second is page 79 judgment. Rupees 2 lakhs was awarded towards loss of future prospect, Lordship. Page 79.
No, total awarded
Total awarded sum is 7,49,788.
7,49,788. And
Plus
2 lakh.
interest. Lordship, 2 lakhs was awarded loss of future prospect. Lordship.
So regarding quantum, you are challenging and
Yes,
the
yes.
disablement
And
certificate.
disablement. Regarding
No, quantum disablement is okay. 2 lakh, but what is the procedure with regard to temporary disablement?
Yes,
Permanent
but
disablement.
Lordship, that is need to be reviewed after 2019.
No, for
That
example,
was
the
not
doctor
done.
says that it's a temporary disablement.
Temporary disablement.
Now, what is the procedure?
But after 2019, no, nothing was done. Even it cannot be said after 2011. The treatment sheet is till 2011, only for that 11 days. Thereafter,
That is there, but that means there is a latches on the part. So for that
but
latches,
after 3 years, why after 3 years he went to the doctor for disablement
no,
certificate?
that is there. The board has examined everything because it is done by the due
But
process.
that is for up to 2019.
Yes. Now the question, that is the question.
But
So what is the procedure in the case of assessment of temporary disability? Any other procedure let down?
we generally followed the judgment which Mr. Singh has handed it over in the earlier case, Rajkumar versus Ajay.
That is temporary disability.
No, no. How is to be considered?
That is there,
That
but
is there.
when that case was permanent disability, this
Yes,
is temporary
Lordship.
disability.
Yes, Lordship. That is strictly it is not. But here the court has considered according to the
So in
permanent.
that case, future prospect may not be considered. Future prospect.
But even in case of this loss of future prospect, he was a student of engineering course. Why he has not completed it, that is also not sure. How it has affected, made any causes loss to his future prospect, that is also not clear in this case from the depositions and from the evidences.
Question is, you see, temporary disability is one thing, that is the procedure, but the disability is there. But that disability
is there, but here the learned tribunal has considered as if a permanent disability.
May I ask it, Lordship?
because there is no other procedure with regard to temporary disability. So what is to be just and reasonable, that can be awarded. Even taking the guidelines for permanent disability and proportionate deduction.
But
that
what is the present physical condition at the time of passing
very well,
judgment? That
when some
because
temporary
that disability is for 2000 up to 2019. Thereafter, it was not reviewed.
Therefore, it is not reviewed yet.
And
That is the latches. So
there are no evidence that whether future treatment.
that is a
he has done.
full-fledged. Is a full-fledged. What does the guidelines say? Medical guidelines that he will be full-fledged. Any type of expert examine.
It affect the future workings of that. That is
Now,
required.
what is there in the cross-examination regarding future prospect?
Nothing came.
No, you see, disabled persons also get job. There is no doubt
Now,
about
why
that.
he has not completed BE course? That is not. Nothing is there, Lordship, in the cross-examination of PW1.
But he has not
Page number
completed. No, in the chief, what he said that he could not complete due to his disability.
In the chief, it is now I cannot work and work properly. Now I'm
No,
preparing.
in the chief regarding a examination course completion.
No, nothing is there. Page 11 is the chief. Nothing is there.
May I?
He was only stated I was 23 years old at the time of accident. I was a
No, in the
student
chief,
of
yes. No, let us come to his examination in chief. Yes, I was 23 years.
Yes, Lordship.
I was removed. I was a student of BTech.
BTech.
Now I cannot work.
But this is not proved. Now we cannot work and work properly, Lordship. That is not proved. Because even in the examination in chief and the disability, it is fact that without any assistance of escort, Somen Mondol can travel. That is the evidence of doctor, page 20, who has issued the disability certificate.
So 8 lakh was prayed for. And how much was awarded? 7.
7,49,788. That's the interest.
Yes, with regard to permanent disablement, it was cited. Anyway, regarding cross-examination, whether he is able to work now or not.
Nothing came
Oh,
out.
whether it was put in cross-examination.
No, nothing was put. That I don't know, but in the page 14, nothing is in that regard regarding his disability or anything.
The accident took place in 2014.
11. No, 2011. 5/9/2011.
And this is 2019.
2019.
Yes, that's all.
Yes, so these 2 points are mainly, Lordship.
Yes.
Lordship, kindly first point.
And Lordship, I am relying on these 2 judgments.
কোন জাতি দিচ্ছ?
আমি একটা রাজকুমার দিচ্ছি আর একটা উত্তরপ্রদেশের সঙ্গে বিভোর পাইলাম, এই দুটো দিচ্ছি।
রাজকুমারটা
রাজকুমার।
পড়ে তো আমি একটুখানি দেখি তারপরে দেবো।
আচ্ছা,
রাজকুমার পড়ে দিও আমরা।
আচ্ছা, ঠিক আছে। Then after he is finished, I will put.
Lordship, will deliver this. Lordship, kindly come to page
39.
Lordship, kindly come to page 39. The disablement certificate. Somehow or any of the situation, under the compelling circumstances, the doctor said the age not mentioned, but age mentioned. So kindly come to the page 39.
Page 39.
Also kindly see age about 26 years. Because there is the format. This cannot be, there is no way to escape. Page 39, it is a
Age of injury is not mentioned.
So age about 26 years. Thus you got it?
Page just.
Page 39. Disablement certificate.
Age 39 years.
Page 39.
Page 39, age 26 years. Yes.
Unless you kindly see the left-hand side top, disablement certificate. The certificate issued as per order number such and such. This is the government order. The certificate has been prepared or after examination, whatever that is the government within the government infrastructure. So the certificate issued by the government order dated such and such. Let me kindly see the memo number. Everything is there. So that is there. And Lordship, kindly see the my learned sister also raised one.
No, here one thing is there.
Lordship.
Disability report is caused by injury.
Yes, that is
The
RTA.
certificate it is there.
Yes, RTA caused injury, everything is there. Lordship, kindly see column number 1. Physically, orthopedically, RTA with doctor handwritings cannot be Anyway, Lordship, whatever, ultimately come to a conclusion that 55% disabled person. There is no doubt that certificate is examined, doctor has come and issued the certificate that has been executed in accordance to the law. But Lordship, kindly see that for 55%. So Lordship, is question of cannot be reviewed. Suppose Lordship, today is the place for review and another certificate has come. The court will consider, suppose already disposed of, they prefer an appeal. So the certificate will come. The court will consider that second certificate. The perpetuity cannot be considered, cannot be entertained because on the date of cause of action, the date cause of action that has to be considered. On the date where the victim received injury, on that day he was more than 55%.
There are different categories, you see.
Yes,
One
kindly,
is
kindly.
permanent disability, temporary disability, partial disability.
So, Lordship, partial disability is cannot be.
Maybe permanent, partial permanent disability may be there.
But Lordship, beyond, we cannot, before the appeal court, we cannot submit anything beyond the evidence. So whatever evidence available before your Lordship, we will go by that. We will concentrate our
The
submission.
procedure to ascertain temporary disability is the same as that of permanent disability.
Maybe, suppose, today he has brought another certificate, his disability increased. So my humble submission, that cannot be entertained by the law, by your Lordship. Suppose they are reviewed and the disability person is increased. So that certificate cannot be entertained by the court of law because of the perpetuity cannot be going on. Once the certificate issued after the treatment, that certificate will prevail. Am I clear, Lordship, on that issue? So the temporary 55%, so it will get 55%. Suppose the case of amputation. Lordship, kindly visualize the situation. Case of amputation. The question does not arise for permanent or temporary, is absolutely permanent. So I cannot develop the case. So
the question is what is because here there are categories, you see. The percentage of disability, you see, the Motor Vehicles Act also provides the disability that is permanent, 50%, 60%, whatever it is.
Yes.
But here you see the percentage of disability is there, but it is temporary. The statute does not say anything about temporary disability.
Once again, Lordship, at the time of accident, on the date of accident, it was more than that, usually. But after prolonged treatment, he has come to a conclusion 55%.
No,
so
that
prior
is
to that, so the cause of action is very important. As and when, because he is entitled to get the compensation when the incident or accident happened. It is no doubt, there is no question. So they have filed application after that. Now, after examining after administered the medicine, after taking proper treatment, then the conclusion is 55%. It means prior to that, it was more than that. But at that, I cannot say if it is more than that, Lordship can consider that. I cannot say that. Because of once after prima facie treatment, it has come 55%, so we will go by 55%. So certificate as issued by the doctor, there is no ambiguity. There is no ambiguity.
No, but why he has said temporary disability?
So whatever
he could have said permanent disability.
Whatever doctor is it, the medical opinion.
Whatever it is there. So what should the court do? Follow this temporary disability because there is the law is silent on that. The law provides only with permanent disability.
No, Lordship, no.
So where
I'm sorry, Lordship. Sorry, Lordship.
No,
that is not that. This is a temporary disability, so he will be washed out. He will not get any compensation.
Why does it? Does the same parameters apply in case of permanent, temporary? That is the question.
Permanent, temporary. If it's a permanent, the future, the
future prospect is to be taken into consideration.
Future also taken into consideration in this case also. Future prospect, there is no obligation, there is no scope to avoid. The future prospect has to be in all cases. The Supreme Court says is Hemraj case, the Punoi Shetty, the future prospect that has to be considered. There is no way. There is no way to ignore this future prospect. The age is 26 years. For 40% future prospect has to be considered in respect of the income of the deceased. That has to be. There is no way. There is a plethora of judgment of the Honorable High Court, Honorable Supreme Court that never declined the future prospect will not allow. Future prospect obviously allow. And my analysis also appeared in so many cases. He also appearing in the insurance company. I think he will assist the court in the injury case. the Punoysheti 40% future prospect is absolutely applicable. There is no way.
No, that
And loss-
Punoysheti is injury case or
Death
permanent
case.
disability? No, forget about death case. Punoysheti is
Punoysheti ratio of future prospect.
no, in case of permanent disablement. What?
Punoysheti is a death case. Punoysheti is the
Punoysheti.
a death case. Punoysheti, but the ratio of this judgment of Punoysheti regarding future prospect is equally applicable to the injury case. That is my submission. Equal applicability to the injury case. If this 26 years old, then 40% future prospect has to be considered.
Yes, only you see, in injury cases, only in case of disablement, the future prospect comes, permanent disablement. Simply if it is a pain and suffering, there is no disablement, then future prospect does not come.
Yes.
Suppose only medical expenses and pain and suffering, there is no disablement.
With get respect to this, I am debarring the lordships, just discussion going on. It is no way. So in the future prospect, if we will go by the certificate.
No, suppose that, no, in this case there is certificate.
There is certificate.
Definitely that has to be followed.
That has to be followed. So
only thing is this temporary disablement. That is the thing.
The temporary disablement, it doesn't. Here is no. There is. It will recover immediately. But because of further reason, he said 5 years. After 5 years, he will come further for review. But after 5 years, he has meet with the medical person or not. That is immaterial. Because of if you meet with that, but suppose that the disability is in increase, then I cannot produce the certificate.
What is the cross examination of the medical person? Let us
cross examination medical person. Also kindly come. Also kindly come to page 18.
Cross examination. Page
No.
number 20.
No, page number 20. Page number 20. Presently, I am prostate orthopedic surgeon, Huldia. Such and such, the medical board was constituted consisting 3 doctors, namely myself and Dr. Bhattacharya and Dr. Haldar and Dr. Gupta. On that day, Showman Mundo, such and such. On examination, we found RTA was post-traumatic, post-operative stiffness of right knee and ankle zone. Let's kindly see the nature of injury. Is recoverable or not? That is not the issue. Let's kindly is traumatic, post-operative stiffness of right knee, ankle zone. Is the stiffness of right knee, how the person will walk. How the person will work? Is the just 26 years old, is the BTech student. Interlife you will suffer. Money cannot compensate the human life. Whatever amount lordship will give, it is not that they will recover from this suffering. So 7 lakh is the issue. Issue is that the post-operative stiffness of right knee. You kindly notice that mark it. At ankle zone. You kindly see that. This injury are caused due to road traffic accident. We unanimously opined that Suman was suffering 50%. So the doctor's medical board come to a conclusion is suffering from 55% disability. How he has come to the conclusion that he has defined in that cross examination. See that what is the nature of injury? Money can he cannot go to the original life. I am not arguing on the issue of money. I am issue that how the doctor has come to his conclusion.
Injury was temporary in nature.
Lordship, kindly see. So if this is the situation when the evidence was taken, Lordship, kindly see the date. 9 November 2022. Lordship, kindly come to this.
An examination 2014.
Examination
2019.
2019. Accident took place 2011. After 5 years, he is suffering till 55%. Kindly visualize the situation, Lordship. So what is the law? Law is that at the time of incident, the insurance company will pay. That column is there. We approach, they did not pay. That's why we have come before the Lordship's court, come before the original court of law. So after examination of 4 years, he has come to a 55%. So prior to that, date of accident?
No, 11 plus 9 is 8 years.
8 years. 11. So prior.
No, the examination was in 2019.
2009.
An incident 2011.
Lordship. So it means 8 years. So after 8 years, 55%. So at the time of incident 2004.
Examination in 2014.
Examination?
In 2014.
No, no, no.
না না এই তো
This is 3. Witness number
Oh,
3, it is.
sorry,
No,
no,
no.
2014.
14.
He's correct.
Oh, so
2014.
but this claimant.
No, no, disability certificate is
Disability certificate.
Disablement certificate 2014.
14.
2014.
Incident 2011.
2011. After 3
So
years.
2011 incident happened. 2014 disablement certificate issued. On that day, doctors found 55%. So logically, visualize the situation at the time of incident. What was that? That will never consider by lordship. Only the after 4 years, 5 years, he's developed.
This is 2014.
So, so the person develop his physics. So that's why he will suffer. That cannot be a law. He's developed. So up to after that 55
Now the question now, another thing is, it is a fact without an assistant
maybe
can travel.
Can travel.
Can travel because of there is another problem in the question of law. Because of lawship, then
So where do we get that? From the certificate that the case does not require review after 5 years?
Yes.
The case does not require review after 5 years. Usually,
case does not and the column number 3
requires oblique does not require.
lordship, kindly see column number 3.
no, no. This is cross-examination.
Cross
No, no, lordship, from the certificate lordship will found.
That is page
39.
39. Yes, column number 3.
Yes. Percentage of temporary disability variation calculation as 55, and the case require 5 years.
And the case requires or does not require
After 5 years.
No, that is not there.
That is not there.
Not at all mentioned.
Not mentioned. Not the tick mark.
Whether if the case requires, that is 5. That means after 5 years it was this.
So within 5 years, no question does not arise. That's true.
No, question is if it is 5 years, okay.
Yes.
Then it ought to be reviewed. But at the date there was no scope of review.
No.
And at the date of examination.
No.
After 5 years it requires review.
It requires review.
Okay. But at the date of examination there was no question.
No question. So
the second thing is this, it is also requires.
Yes.
Here they have not put any tick mark.
No.
That case requires review or does not require review. Neither of it is. Only in the cross-examination it is said.
Lordship.
In the certificate it is silent.
Yes.
Because it is said it is valid up to 1811.
Anyway, if it is valid, so far as certificate is valid, okay.
Up to 5 years.
But this one, what is the necessity of this one? Requires or does not require? That means either they have forgotten to put the tick. Either it will require, they will put the tick. Requires 5 years. Does not require.
Does not.
No, he has stated.
He has stated, but certificate does not.
Differing from his statement.
No, he has stated that in the certificate the case does not require review since it is valid into 1811.
Cross-examination is appear. Cross-examination it is appear.
Without cross-examination.
But the certificate, lordship, kindly see the
certificate is by the board.
Certificate by the board is silent over the issue. Lordship, apart from that, my humble submission, within 5 years, no review is required. Up to 2014, no review is required. After 2014, review is required. So my case within 2014, not beyond that. So you can note it that after 2014, there is no review. But my humble submission, 5 years, not require review within 2024.
Yes, had it been permanent disablement, no question that after 5 years or 6 years.
Lordship. But is it temporary? That's why required. But lordship, my humble submission within 2014, not 15, 16. But up to 2014, 55% is there is no issue, is no ambiguity. That's admitted case. So question doesn't arise for 55% for consideration. The learned tribunal considered this is rightly considered. Then lordship kindly come to that the learned tribunal considered is whatever the evidence is available before your lordship, I cannot submit beyond the evidence. So lordship will find that the learned tribunal consider one BTech student consider 3,000 per month. Just kindly see that. The BTech student is 3,000. And lordship kindly come to my claim application page 2.
It's the paper book. Page?
Page 2. Column number 6. Just see in what manner the claimant approached before the learned tribunal. Page 2 of my paper book. Go ahead. Column number 6.
Yes.
Just see column number 6. Monthly income the person injured does not arise. So we didn't approach anything before the learned tribunal because of being a student. So is totally is the discretionary power of the court, how in what manner the learned tribunal come to a conclusion. So the learned tribunal on its own discretion come to a conclusion is BTech student. Is BTech student, there is no that admitted, but not completed, that evidence is there. So clean hand they have come, but consider 3,000 per month. Just see. Just see. So what more I will pay before the lordship? That is required to be interfered by the appellate court. The 3,000 is the absolutely lower amount, bigger amount that has to be taken into consideration. For the learned tribunal, consider 3,000. It is a good academic career that the evidence is before your lordship as well as before the learned tribunal. After looking into that, learned tribunal come to a conclusion there is no evidence in support of his income. So question does not arise with the student, but evidence is will place. But you also kindly see that the BTech student considers the 3,000. So the person has some
you see, in case of death, you see, notional income has to be taken a particular. In case of this injury, a notional income has to be taken.
One thing, lordship, notional income is whatever lordship will use, that is the notional income. Notional
Yes,
income cannot indicate any figure.
same parameters do not apply in both this type of cases.
Lordship kindly
Yes.
see that. I am blessed, lordship. But lordship kindly see that BTech student, it cannot be treated as a day labor. I'm bound on lordship. I have no submission.
He may do some coaching very well. That is not unnatural.
So, no, not yet started his income.
No, at that point of time.
That point of time. So today this situation cannot be entertained. What was the situation and in the 2011 that has to be considered. But this 2011, the person is a student, is just verge of completion. So is 3,000 is right, lordship. May I just put in the question, being a student of law, to my teacher, this is 3,000 is right. Kindly, lordship, just note it down. Lordship was finding the page. Lordship, page 79.
Yes.
Lordship will get the entire. Lordship, medical bit that has been awarded. There is no grievance of, I think, my sister has no grievance.
One lakh 13,188.
1 lakh, that is 77.
Anyway, 1 lakh is awarded.
1 lakh awarded.
No, 1,13,188 it is awarded.
No,
1 lakh is
medical
towards
bill awarded totally. Page 79, lordship, kindly see the breakup.
Yes.
those were exhibit
3,000 into 12.
Into 12
into
into 70
20
multiplied, rightly applied, and into 55%. So lordship, 55% means it getting the 55%. This means
That is, it comes to 3,36,000.
6,000. That is the loss of income. Just loss of income. Kindly see that.
Okay, then medical bills is 1 lakh.
Medical bill, they awarded calculation, whatever they awarded. I am not disputing that, my land not disputing that. But my land disputing that the education intention awarded 2 lakhs towards loss of future prospect. Landowner also awarded 1 lakh pain
No,
and
that
suffering.
pain
Pain and suffering is 1 lakh.
one.
Pain and
That I
suffering,
know not.
that is also
disputed.
he's not disputing. So kindly mark
So
that.
3,36,000.
Lordship, so far the income, it is of 2011, Lordship.
Yes,
And
2011. I am not.
income is considered, and why has it not completed BE course?
Why
that
not complete?
is
That is
not
traumatized.
that
But
is not reflected from the cross examination. It is my learned friend's assumption. Nothing came up. He was a
Now the
student.
question
but
is, you see,
why
3
he
lakh.
has not completed?
Not
The medical
complete,
treatment
not
paper shows only 11 days.
That's a different issue. It may be his latches also.
Yes,
Now,
Lordship.
now the question is, how far he has suffered.
Yes,
That is the question.
That is the
Now 3,36,000, that is there. Calculation comes.
Yes, Lord.
By considering the monthly income 3,000. I have a cost objection. My humble submission that should be more. So medical.
This we cannot
medical
dispute.
bill,
That is proved to
pain
be
and suffering not is
only loss of future prospect, Lordship.
Future prospect, that is 2 lakh. 2 lakh is
Lakh was
granted.
awarded, Lordship.
How much is granted? 2 lakh.
2 lakh. Because nothing came up from the evidence that he has suffered any future.
That cannot be. That cannot be. That
Even
submission cannot be.
in his cross-examination,
Okay, considering the age and education intends to award 2 lakh.
Lordship.
but education he has not completed. What may be the cause that is not?
He was traumatized. He was received an injury. Can you visualize the situation?
But he was only 11 days in hospital.
How many
No
days is
further,
required to be hospital?
further, no
So
further treatment
for
or
the
nothing,
compensation,
anything.
That is the vital thing. You see, it is a medical board's assessment.
So that is true.
And Lordship kindly see.
But why he is
evidence,
not completed?
Why is not completed? Who will say?
Maybe that is 2014. Thereafter, he may have
He may
completed.
have completed.
At the time of award.
No, his examination was
2011, 12, 14.
Yes.
No, his examination was done in 2019, Lordship. In the cross-examination in 2019, he has stated, I did not complete my BE course.
No, it may be possible that
In the
shifting to some other courts may be possible.
Lordship, though,
That is what came up from the evidence.
Cannot be
Nothing.
drawn up.
Nothing can be drawn up from whatever is not in the evidence.
But that is admitted that he was studying in engineering.
That is admitted, but he did not complete his BE course. That he has himself stated.
That can be a prejudge issue.
Maybe for his loopholes he has not completed.
Maybe.
Nothing. Maybe.
Who will, your submission cannot be considered in such a
Now, here is considering the age and education.
Lordship, kindly come
So,
to
his age was considered, his education was also considered, and 2 lakh was awarded for future prospect. So, only thing you are disputing rupees 2 lakh.
2 lakh and that 50% as a permanent disability it was considered.
That cannot be.
No, if it is
Then
temporary.
because it is up
Now
to
the question is, if your case is accepted temporary disability up to this
up to
period,
20, that is
so this future prospect can please. Now the question is, if your stand is accepted regarding future disability, the permanent temporary disability, so future prospect goes.
That's why I
because
these 2 points.
Okay, no. So 2 lakh. So at best, if your contention is accepted that it is a temporary disability, future prospect, there is no question of any future prospect. Then in that
because
event,
it is not proved how it is affected.
So in that event, at best, 2 lakh will go. Nothing beyond that.
Because in this case, as if a permanent disability the court has considered.
So proceeding on the permanent disability.
Yes, Lordship.
Yes, anything else?
Just I am concluding my submission. Up to 2014, the certificate issued, I will go by that, because of after that, if the certificate is issued, there is no law to entertain the certificate. So 55% disavowalment issued by the medical board of the hospital, that has to be considered. The learned tribunal consider the same. I will go by that. Number one. Number two is future prospect that has to be considered. The learned tribunal consider 2 lakhs very well. I am not disputing that. And one last submission is there, Lordship. 3,000 considered by the learned tribunal is the one, Lordship, 3,000 is the labor that a student cannot be treated as a labor. So, Lordship, what figure I will submit? Lordship, kindly take it as a 5,000, at least deserve some respect. So it cannot be a 3,000. In 2011, 5,000 is very well. Is a minimum wage is that 5,000 is very liberal approach. I can say more than that, but whatever the liberal, what is the at best Lordship can allow, because of I am being officer of the court, I am saying Lordship, 5,000 kindly consider as a monthly income. And Lordship, 2,000 to 2 lakhs awarded by the future prospect. That future prospect, there is no way, in view of the Punasheti case, there is no question, doesn't arise to avoid this situation, not in past any future prospect. In every case, future prospect has to be. In injury case, also the ratio has to be applied, has application. So Lordship, kindly consider the 5,000. Lordship will supply the calculation on basis of that. Because
Anyway, what
monthly income part is
anyway, that is your appeal. Okay, that quantum, that monthly income aspect.
Lordship.
And your learned friend's appeal is with regard to the
My learned
with
friend-
regard to the quantum, that is future prospect, and the disability certificate.
Lordship.
That is the calculation.
So Lordship, only kindly consider this 5,000 subject to, obviously, Lordship, can be treated as a day labor. So day labor would have earned by 100 rupees per day. That is the judgment of the Supreme Court, 3,000. Lordship, I admitted that, but Lordship cannot be treated as a day labor. He's a student. That part has been confirmed. After that, what happened now? That cannot, on presumption, I cannot say anything beyond the record. So he's student. So kindly at least take the 5,000 per month and consider his future prospect, whatever is come from. And Lordship, one thing, so the learned tribunal considered the future prospect 2 lakhs. 2 lakhs. 2 lakhs. 2 lakhs.
Loss of future.
So it is not that there is no loss of future. He can run as a ordinary person, or whatever money, my submission, whatever money Lordship will allow, the person cannot come back to his original position. So some future loss has been suffered. Some local prestige, he cannot join in the army. He cannot approach to them, 26 years old. He cannot join, he can approach to the administration department. Kindly that suffer, who will meet that? So for the reason, 40% future prospect is not the 100% future prospect I am praying. But in the injury case, Lordship, he is suffering 100% future prospect. But he cannot apply for any defense. He cannot apply for any administration, state administration. So and even then, he also receives some pain from society because he is a handicapped person, 55%. In entire life, he will carry this certificate of 55% disabled person. Entire life. Who will pay? This is not the loss of future prospect.
No, you see, when it is temporary for a particular, if it is reviewed after 5 years or so.
If it is reviewed and they say 0%, suppose it's 0%, suppose, then what will happen? And then Lordship, another thing is,
you will not be treated as a disabled person.
Very well. Suppose after reviewed, the 55% above 65%, then what will happen? He can approach to the court further to the tribunal. Yes, my 55%, I filed a claim case. Now I'm 65%. No. So people simply said no. That judgment also there. After review, judgment over. Everything is over. High Court also interfere.
So which judgment you have relied upon? Oh, you will rely tomorrow.
No, that judgment I am not relying upon. Lordship, kindly, because of my humble submission is that 55% disabled. Lordship, kindly consider that that future prospect should not be avoided because of the ratio is applicable. My learned sister also knows the ratio is equally applicable in the injury case. So learned tribunal considered the aspect. Only my humble submission 3,000 to 5,000, nothing more. So whatever judgment is passed by learned tribunal, that will remain. Only 3,000 to 5,000. That is my humble submission.
Anyway, your judgment is only that, which is
only that part. Because of that part is
My
there's a submission
grounds of
advanced by
appeal is only on two grounds.
so submission advanced by the appellant on presumption. Why he did not complete the education? Why he not reviewed? That's the presumption. But what my submission
not reviewed,
within
that
the,
is for a
that is
period.
absolute presumption. There is no record. There is no submit. There is no paper.
the thing is, you see, this percentage of permanent disability, it 50%, it may be 60% also.
Yes.
If it is permanent disability, there is no provision of regarding review.
Rashid, the part, my cross option is that the person has to be treated as a 100% disabled person. But I cannot prove that. Suppose Lordship, suppose someone Lordship this 10% disability, but due to 10% disability, he cannot perform his duty what he used to do before the accident. Then person has to be recognized as 100% disability. That's a kind of visual situation. Suppose someone lost his hand because she was by profession a carpenter. She cannot perform his duty as he wished to do before the accident. So loss of finger or lost 2 fingers, then is whatever 20% disability. So 20% disability can be treated as 100%. But here he is a student. His prospects, the prospect of the student not yet been determined. Once the prospect of the student not even determined, that the future prospect cannot be declined. So kindly record my submission that. So once the prospect not yet been determined.
Yes. Anyway, I shall consider. Yes, what are the judgments?
Submission is that 3,000 cannot be give some respect to my.
No. 3,000 is not very unreasonable sum.
Lordship, I am relying on this two judgment. Kindly go through paragraph number 12 of Rajkumar.
Lordship knows this Rajkumar judgment.
Okay, this is there, no?
It is of 2011.
And before. And Lordship, one thing, before judgment, Lordship will found one thing where the person is walking, is, absolutely can walk. In the judgment referred by Lordship will found on that. That evidence is not there. On that evidence, the before judgment has come. So before judgment is not applicable in this case. Because of in this judgment, he is as it is as he was. That's why Supreme Court passed the before. Before can be a precedent. But Ajay Kumar Rajkumar, Lordship kindly see that Ajay Kumar Rajkumar is the precedent. Absolutely is the precedent. But before that judgment is the absolutely for one case the Supreme Court delivered the judgment. That judgment was not under Article 141.
After all, you see, the statute empowers the court to pass just and reasonable compensation.
Yes,
by following these guidelines.
By following the Punashiti guidelines.
Yes, that is the guideline.
One thing is absolutely depend on your Lordship. Lordship also already expressed Lordship judicial opinion is that the monthly income has to be interfered. Whatever Lordship will interfere, Lordship will interfere. My humble submission, kindly consider 5,000, 2011. It will be reasonable for my client. So, second is that the prospect not yet been determined. So, the future prospect cannot be denied.
Yes,
Lordship, the awarded sum with interest was already deposited before this.
So, the award was passed in 2020?
24.
24.
Award was funded 24. 21st of December 2024.
Thereafter, you deposited.
Yes, as per direction of this honorable court, I have deposited.
Yes, learned advocates for the parties are present. Heard learned advocates, hearing is concluded. CAB.
Lordship. No date.
CAB is judgment.
No, I'm giving date. This
Judgment.
This